and they are the strength of the bar. And I salute their devotion and contribution to the bar. All members of the ITAT Bar Association who have joined in today and our guests, I'm extremely grateful to you to be participating with us. I now hand over to Shri Ajay Wadhwa to take on the proceedings from here.
Thank you, Aris. It's a wonderful introduction, as always, by you. Honorable Shri G.S. Pannu, President of the Tribunal, honorable members of the Tribunal, Varshney Sahib, my friends, experts for the day, ladies and gentlemen. You know, it's a nostalgic moment for me personally, and I will just briefly give you a picture of how it is so nostalgic. You know, about 25 years ago, there's a gentleman called Shri G.S. Pannu, who used to be the president of the NIRC, Northern Indian Regional Council of Chartered Accountants, the same Honorable Shri G.S. Pannu who you see today. He was then the chairman of the NIRC, and I used to be his convener of the taxation study group. And as the chairman of the NIRC, he had made it a point to call all the chief commissioners who used to be in Delhi. There used to be 3 chief commissioners along with joint secretaries for discussion, for alleviating issues relating to the chartered accountants and the bar. And I used to convene the meeting, and he would be the chairman, and then we would have the department. So the nostalgia is that today again, I am convening the meeting. The chairman has become the president, and the department is there always in its youthful form, the way we find Kamlesh Varshney. So, sir, I hope you remember that. And the life goes the full circle. And the slight difference, and then again, there's no difference. You know, I used to dye my hair dark 25 years ago. Pannu Sahib used to dye his hair, specks of hair gray 25 years ago. He continues to do that. And the department used to, again, be as useful as it is. Now, friends, with a little, the problem again here with faceless, with virtual is that when you crack a joke, you laugh yourself. You don't hear anybody else laugh. That's another very big problem. But anyway, that's the way I think we've got to adjust to this also, like we've adjusted to the virtual so far. Now, sir, my trademark is that I speak little on the subject and a lot on other issues which are plaguing my brain, and I will not deviate from my trademark. So first issue, the thing that bothers me, this time around, we find that in the memorandum, there's a brilliant attempt to justify why certain provisions have come in, for example, cess, 14A, judgments have been cited of the tribunal, of these high courts, and a view has been given as to why the government feels that cess should not be an allowable expenditure. It's a good thing. But I think it's a post facto. There are certain things which we need to anticipate and provide for. Now, and as I go on in the next 5 minutes, you will see that we do a lot of things when events have happened, a lot of costs have been incurred, a lot of time hours have wasted, and then we take remedial measures. Now, for example, just to give you a little example, now, updation of returns. It's a great step. But as we will go along, now there's a provision which says you can't update your return if the assessment is pending, reassessment is pending, recomputation is pending, or revision is pending. Now, obviously, it comes to my mind, what is the recomputation which is pending? Is it 143(1)(a)? What is the recomputation? Is it a 154? And what is the meaning of the word pending? Does pending mean that notice has been issued? Or does pending mean the time period for picking the case for scrutiny has not expired? These are all the things that will come up instantly when you read the section. And what will happen? What will happen is we'll go the whole circle. 2 years from now, when we will have had high courts diluting the provision, giving their interpretation, then we'll be doing this. So my point is a good attempt has been made to clarify, give reasons why we are doing this. But even it's a better step if you clarify firsthand as to what you mean by certain words, certain, don't presume that only the lawyers and chartered accountants are supposed to make meaning of these words. Let it be for the common assessing. Then again, in updation, you say the assessing officer has information and the information is communicated. If it is communicated, you can't go. Now, what is communication? That again can be an issue. So I'm saying a lot of these, probably a clarification, the view of the government could come in so that these problems are obviated. Second, now, sir, so many years have passed since 1961. There is a very basic understanding of what a binding precedent is for us. For us, a binding precedent is if either in a writ or in an appeal, the High Court decides a legal issue, it is binding on the subjects within the territory of the High Court. When we say it is binding on the AOs also. Now, sir, you won't imagine that we had a meeting with 200 participants where this recent amendment, 148 notice issued after 31st March, which has been quashed by the High Court in a writ proceeding. My point was, why go into writ? If there has been one decision by the High Court of Delhi, then it applies to all, and the assessing officer should drop the proceedings. He should say, I have to follow this legal decision by the High Court, I will drop it. A circular should have come from the board saying, please drop. Now, what has happened is no clarification, and a brilliant officer of the stature of Shri G.C. Srivastava had to say that, listen, Mr. Wadhwa, don't be too sure. If you don't go into a writ, assessing officer will still add, will still continue with the proceedings. Now, that is not good. Now, what could be the solution? The solution could be that obviously you are going to the Supreme Court on this. One of your grounds in the Supreme Court could be that if you decide against the High Court, then also write that all the proceedings which have been dropped will be revived. High Court can pass any order, the Supreme Court can pass any order. But at least instruct the officers. Now, sir, उसके बाद हुआ क्या? जब ये एडवाइस मुझे मिली, मैं सबको ये कह रहा था, कोई don't go into a writ. 15 केस मैं भी रिट में ले गए. और कल बैठे हम उसमें कोर्ट में बैठे हुए जज साहब आए, उन्होंने कहा it's covered, finished. So about 2,000 people have gone into it. Look at the enormous waste of time of the court, enormous waste of time of the public. So these basic things. Then, sir, look at the faceless issue. The writing was on the wall that in our country, so much jurisprudence has flown in on the principle of natural justice that 100% faceless in the form in which it was introduced will not pass muster and should not pass muster. You have to give a hearing, either in the virtual mode or on the physical mode. You have to hear me. We have waited for 2-3 years to make this amendment. We have gone a full circle. Where now before the assessment, I have an option to.
मैंने उसमें लिख के दिया ना आपको, मेरे वेडिंग का डाल दो एक बार कि the council.
Please, yeah, okay. No, sir, so we've gone a full circle. So these are the things जो हमारा basic edifice है, the structure है हमारा, that democracy में आपने सुनना ही सुनना है. If that is kept in mind when every legislation is passed, I think the problem would be over. Then, sir, another thing which bothers all of us. Sir, क्या हुआ जब last year आपने कहा कि ITAT is also going to turn faceless? Obviously, we were all alarmed. In fact, हम लोगों ने जो presidents हैं bars के, we formed a group of about 20 bar associations. We got together, and one representation after the other, to the Prime Minister, to the Finance Minister, one representative, please give us an audience. How can this happen? How can the ITAT turn faceless? We went on and on and on. Sir, you will not believe it. Not even one response from the ministry that please come, we are okay with you, we are wanting to listen to you, or not even an acknowledgement of our grievance. That is another very, very serious thing which is happening. Sometimes it looks like there is a wall between us and the other litigating other people. Nothing comes back from there. Anything that we suggest remains there within the four walls. This is not fair, sir. So, isko bring it in the form of a legislation that somewhere If somewhere it has to be, if somebody a representation is made in a proper manner or through a proper forum, it has to be responded to with such and such hour. Do it if it has to be. Then a little about the ITAT. Now this is again, as I said, not necessarily related to the budget, but today we have the occasion, so I'm saying so. And Honorable President Sahib is also there. Now, sir, once the virtual started, and now we know virtual is a rule, even after the pandemic, virtual is not a rule. ITAT geared itself up in spite of the constraints that they had, and they came up. Within 4 or 5 months, all the grievances were removed. Sir, even till date, and I'm on record to say this, when we file our applications, our paper books in the digital form, the honorable members have it, but the DRs don't have it. There are n number of adjournments on the ground that we haven't received it. और उनको दिखा देते हैं कि ये आपके पोर्टल में डाल दिया नहीं. How is it that such a mighty department with such enormous resources is constantly seeking adjournments one after the other on this ground alone? Then even today, adjournments are sought on the ground, record नहीं आया. साहब 10 applications लिख ली हमने. Nothing comes out of it. Why can't a simple formula be adopted? That any departmental officer, whoever seeks adjournment, will send a copy of that to the CC concerned, explaining why he's seeking the adjournment. And why should the CC not on a monthly basis pick up cases on his own and see kitne adjournment ली? We blame the ITAT, we blame so many, but ऐसा नहीं है, sir. That's not the point. Finally, sir, you are witness to another fact. When the settlement commission was abolished, a window was opened by way of 1 month was given for people to file settlement applications in ITAT. And a press note was issued by the department. Press note issue होने के बाद भी departmental officers would not take applications. You are aware? They say कि press note जो है उसकी sanctity क्या है? 3 दिन रह गए थे, CBDT का सर्कुलर आया, 3 दिन फॉर टाइम बार होने में कि आप सेटलमेंट, आप ये प्रेस नोट को आप समझिए इट इज CBDT's instruction. By which time what had happened? Applications had to go in 2 to 3 pages without any explanation because time नहीं था. अब क्या होगा? When it comes before the interim board, 3 पेज की application, it is not true and fair, पढ़ा दो. मेरा ये कहना है साहब, एक पॉइंट और मैं कह के फिर अब सब एक चीज देखिए. We all know that there is huge amount of cash floating in the economy. We also know that post demonetization, people जो middle level पे थे उनके पास से cash चला गया, जिनके पास 1-2 करोड़ रुपया था business करने के, and it is now concentrated among a few people, but it is there. Statistics say so. So all the black money has not come back. It has, I won't say it has increased, but it is there. अब आपने updated return कर दी. अपडेटेड रिटर्न में ये है कि प्लीज आपने अगर रिटर्न अपनी पुरानी फाइल नहीं किया तो कर दीजिए, कभी आज तक फाइल नहीं किया तो कर दीजिए. लेकिन व्हाट अबाउट सेक्शन 115 BBE? आज भी अगर मैं अपनी इनकम दिखाना चाहता हूं, आई हैव टू एस्टैब्लिश द सोर्स. एज इफ आई वांट टू शो एन इनकम, आई हैव टू प्रूव, आई हैव टू गो इनटू सेक्शन 68 टू शो द क्रेडिटवर्दीनेस, द सोर्स ऑफ दैट इनकम, and pay 60% tax. Do you think this problem will ever be solved? Who's going to pay 60% tax plus 25% tax? The money will remain there. These are the ways where you can invite that important capital which is outside and it will remain so. Nobody is going to pay 60% tax. और कितनी searches कर लेंगे आप? Finally, मैं सब एक चीज और कहता हूं. You see, जो CBDT में you'll appreciate TPL is never permanent. 4 साल के लिए आप आते हैं, 4 साल बाद फिर चले जाते हैं, somebody else comes. What is permanent is a counsel and his knowledge. He remains. आप 4, 5, 6 काउंसिल्स को इन्वॉल्व करें बजट मेकिंग में, उनको वही स्वेर ओथ दें कि वो कभी बताएं, सीक्रेसी करें. लेकिन ये सारी जो इश्यूज जो बड़े बेसिक इश्यूज खड़े होते हैं, लेट देम असिस्ट यू सो दैट दे आर एबल टू से कि साहब इसमें फिर लिटिगेशन होने वाली है, इसमें आप क्लैरिफिकेशन दे दीजिए, पहले ही आ जाए. सो मेरा सब with this, of course, I'll keep quiet. And these are some of the few generic points which I thought today is the occasion when all my friends are here, you are there, and Panu Sahib is there, and the experts are there. That these are the things we all keep debating about, all of us in the bar, and thought of presenting it to you. So don't have to react to it, but just for adoption. And with this, thank you very much for the time, Ravinder, that you've given me, 8-10 minutes. Please carry on with the proceeding. Thank you, sir.
May I now request Mr. G.S. Pannu, Honorable President, ITAT.
Pannuji has just left. Just 2 minutes ago.
RS, let's continue with that. I think he's got stuck somewhere.
So should we start with Varshney, sir?
Oh, Varshney, sir, please.
Varshney, sir, kindly make your address, sir.
Thank you very much. So it's indeed a privilege to be here, like last year, and I'm sure we are going to have a very useful interaction on budget provisions, which will act as a feedback for us because these proposals also can undergo change by way of government amendments. So whatever feedback we get from deliberation here are very useful for us to understand how a particular provision will work and do we need to tweak that provision. So basically, coming to the budget that has been presented by the finance minister on the direct tax side, if you must have noticed, the thrust of the budget is that we should have predictable and stable tax regime. And that is for the reason that last year also tax rates were not amended. This year also they have not been amended, even though some other countries during this time, during COVID period, have introduced new tax or have increased taxes because every country wants more revenue to fight this pandemic and to lift their economy. But India has managed to keep its rate stable and at the same time have carried out changes because of which tax collection has seen buoyancy like never before. Yes, there are always room for improvement, as Ajay has said, but we also must appreciate that without increasing tax rate, only because of administrative efficiency, which has also been achieved by regular legislative intervention, that tax collection, whether on the direct tax side or on the indirect tax sides, are seeing very good buoyancy. So, when we talk about legislative intervention, then last year also we had carried out certain legislative intervention so that the collection is improved and there is a tax certainty. And this year also you can see that there are provisions which can help us to improve voluntary compliance. There are provisions which can give us tax certainty. Of course, Ajay ji has said that, why wait for so many years to give a clarification. That's true, because sometimes you feel that these controversies will die down on their own. But, when those controversies do not die down, then, clarification is provided through explanation. But yes, one can always argue that why this year, why not tomorrow, why not yesterday? So those things can always be argued. But the idea is that so long as there is an attempt to provide clarification on a particular provision, that attempt is a good attempt. Updated return, in my view, is one of the best thing that has happened. Once again, you can argue that why it happened today, why it didn't happen yesterday. But the idea is that, there is a particular direction that the tax administration has taken. You must have noticed that earlier, whenever we used to collect information from various sources, we didn't used to share that information with the taxpayer, and we straight away used to issue 148 notice, and that used to lead to a lot of litigation. So that process has already undergone change. now we populate your e-filing account with all the information that we have, particularly with regard to interest, dividend, capital gain, share sales, and all those information, so that at the time of filing of your return, you know what is that information you need to take into account. But then after that, what we have planned now is e-verification scheme. That e-verification scheme has already been notified under section 135A. So the idea is that even after showing you some of the information and you having taken those information into account in your tax return, there would still be information coming from some other sources about your transactions. Now, we will examine whether those transactions are reflected in the tax return or not. There is no proposal to issue 148 straight away. First, there is going to be e-verification. So when we do e-verification, that is a time when you can explain that everything is accounted for, or you may realize that you might have missed out some some particular transaction and you need to account it for. But then for that we need to provide you time, so that you can update your return. So that is the idea behind this provision, that we should give you time to update your return, but then that updation of return should not lead to casual behavior at the time of filing of return, and therefore some additional tax must be there, so that if you have missed out earlier, you pay some additional tax, so that it should not become your routine behavior, that you know that I have a time to file updated return. It is only for some mistakes and all, and therefore the point which Ajay ji made, that 115 BBE taxation is 60%, and then if you are going to add 25% or 50%, it's going to be a huge sum. So basically, I think this updated of return is not meant for those type of transactions that you have huge cash in your house and you want to disclose that cash. It is for mistakes that you file your tax return and then you miss out certain items. That cash which is lying in your house deliberately not disclosed to the income tax department is actually tax evasion, so which should be dealt separately. So therefore, there is a clear direction that that updated return provision is there to encourage voluntary compliance. The idea is, once we have shared all the information with you at the time of your filing of return or subsequent to the filing of return, then we expect that 95% taxpayer would be all right. If either they are already all right or they will become all right by filing updated return, then it is very easy for the tax department to go after 5% rather than 100%. So, so this is basically the idea behind this particular provision. And if there is any, confusion, of course, I fully agree that if any clarification is to be provided, it should be provided so that there is no confusion that what does assessment means or what does recomputation means. The idea is recomputation is borrowed from section 148, and it does not mean that if it is 143(1), then you cannot file updated return. That is not the purpose. So yes, I fully agree that wherever there is a doubt, clarity should be provided. And for that purpose, we expect you to give us feedback. Some clarity can be provided by way of government amendment. However, for everything, legislative intervention is not required. A circular from board may also be useful. So therefore, it is very important that whatever feedback you have, you kindly provide to us. Thank you, and then look forward to the subsequent deliberation.
Varshney ji, I have a question over here. Can I please?
Sir,
sorry, ma'am, we will start that process after a little while. We'll get you the opportunity. We have got Mr. Pannu who's come in. Unka, he had lost the connection. He's back. So, RS, can you request Pannu sir to give us his address?
Can I request you to kindly make your keynote address, sir?
Thank you, RS. Thank you, Mr. Ahuja. Well, sorry, I think there was some internet downslide at my residence, and therefore I lost the connection in between the moment Ajay was giving the introductory remarks. And of course, a pleasant day for everybody. And as Ajay started with the nostalgia of 22 years ago things, yes, to come into a budget meeting is always gets a feeling of nostalgia. There's always so much to look for in a budget proposals which are placed before the Parliament by the Honorable Finance Minister, and this year also has been no exception. I know you have a long schedule chalked out where you would be looking into threadbare of the finance bill provisions, and the list of experts which Mr. Ahuja read out in the beginning. Obviously, in any case, it doesn't allow me to be more generous with my words because less time may be taken wrong. In any case, we are adept at listening, and that's the forte of a person sitting from the bench. But all the same, I'll just like to share with you some of the thoughts which have come into my mind. And first of all, the most outstanding feature when we talk of budget, and budget is not only finance bill for that matter. And so the one thing which strikes out in the entire budget exercise this year is that the emphasis which is there for asset creation, which has gone into very higher allocation towards capital expenditure. Now that's a very, very dynamic call taken by the government, because in the times to come, it's the infrastructure which is going to be leveraged for a better GDP. The resources are to be leveraged thereafter for generating more and more income for that matter. Apart from a very, a short or a medium term objectives of generating demand and supply by generating employment in different industries, which will have the direct benefit of the infrastructure spending from the government. But this is something which is very, very path-breaking. In times to come, this definitely will show up. And the other interesting aspect is the most talked about and yet one has to see how it unfolds is the digital asset taxation which has been brought in. We'll have to see how it works, how the cryptocurrencies will pan out in the country. Well, coming to some of the direct taxes provisions, I have not been in a position to go through each one of them in a kind of microscopic manner which you're going to go through. But 2-3 things we very much stand out. And one, of course, is a very welcome feature where the updated returns concept has come in, where any mistakes which are noticed by the taxpayer himself in a span of 24 months, he can rectify his return in a way and update his return, of course, with paying some extra tax. Well, it's a taxpayer-friendly measure, and undoubtedly a measure which will lessen the burden of the taxpayers. But personally, I would suggest Mr. Varshney is here, if he can, carry on that message. Well, I feel that this kind of measure, there are two ways of doing it. One, it can be slightly more open-sourced suggestions which may come from the taxpayers, because that will make it more meaningful. It will carry more conviction also. And number two, and which is more important, is such like tax-friendly measures should not only be to lessen the burden of a taxpayer vis-a-vis the compliances, but the aim should also be to reduce the litigation, prevent litigation for that matter. For instance, it's a very noble thought that whatever is the data which is available with the government, it is being shared with the taxpayer to see to it that any rectifications, any mistakes, omissions are removed. But for instance, at the time of picking up of returns, you do have norms which you lay down. If those norms are shared even with the potential people whose returns are going to be picked up, maybe they fall in line and they don't come for the assessment stage itself. So one, you're going to reduce your own costs of making assessments by reducing your number. Potential disputes, even the litigation will be reduced. So these are some of the measures as a policy. It's a very good sound policy. You could take it forward by incorporating such things also as you develop, as you mature this policy. So these are some of the things which I saw that probably in these things. Other thing which is notable is, of course, is the effort being made to reduce litigation. We already had that provision of 158A, I think that was the section where the assessees were given the liberty not to appeal in cases where already a question of law is pending before the higher courts. So this has also been extended out to the revenue appeals. Now that's something which is very, very welcome. But why make it so onerous by making it for Collegium of Commissioners and all? the principal CIT who's competent to look at it, whether it should go into appeal or not, is good enough. You see, the idea behind all this should be that you should quicken up not only the decision-making process of going into appeals and not going into appeals. And Varshney ji, you were in the board, you would have gone through and seen the kind of litigation which is there before the Supreme Court also on the delays that is there in the filing of appeals, the delay that is there in the management of appeals from the departmental side. I think this is probably operationally you have to look at the mechanics to see to it that it is very smooth and seamless. And also we come across orders where assessing officers write that only to keep the matter alive, I'm making this addition. No, well, it's his case. He's the client before, he's one of the appellants or the respondent before the court. He is the best person to decide whether I should file an appeal or not. If he is competent to pass an adjudication saying that the matter is pending in the High Court or the Supreme Court or the tribunal on similar issue decided against the bench against the revenue, but in order to keep the matter alive, he is doing it. He is fit enough to even say that let me not file an appeal. I will take recourse to 158 BB or whatever the section you referred to. Why is it you need a set of commissioners to doing that? So therefore, I think it's a very well-intended measure, and it's a measure which will generate confidence in the delivery system also, in the tribunals, in the high courts also, by trying to remove the bottlenecks and reducing the numbers of the appeals. But to operationalize it, you need to make it slightly more easier on the system, on your own system also. See, other aspect is that there should be a constant, perhaps a constant monitoring cell in the board or at a central level who can keep looking at the various high court judgments which come in. And the moment that cell is in a position to accept that principle of judgment laid down therein, it should be informed to all the field formations across the country that in such cases do not file appeals. This is something which will help in reducing litigation, bringing certainty and finality to the proceedings much earlier than expected. So these are things which probably you have taken a very conscious decision. It's a very welcome measure, I would say, from the point of view of a person from the bench on the tribunal. Efforts at reducing pendency and the efforts at reducing the potential litigation, they are very, very welcome. I can go on like this a few more minutes, but one or two things which I again like to share is about the 148 clarifications and all. That's fine. So on the issue of whether it will be prevented by the asset or not, of course, all those things are within the realm of the policymakers, and I'm sure the legislature has done it in a fine manner. I will wait I don't have much time to be present with all of you, but I will certainly wait for the nutshell booklet or something which Ajay will send it after looking at all the provisions during the day. But these are some of the thoughts which I thought I'll share. But yes, it's a welcome measure. No burden is there on the taxpayer as such, but certainly it's done a good job. The CBDT has done a good job in looking at the measures and the in-house procedures to simplify it and make it more effective. And that's the spirit which should be kept up. And all the best to everybody who's joined in today, and of course to the experts. And thank you to the ITAT Bar Association for having invited me. And well, I am not going to say much on the one aspect which Ajay has raised on the concept of faceless assessments, on the concept of faceless appeals. Well, it is still in the making. Certainly, yes. Whatever is done by the board this time, whatever is tabled in the House by the Honorable Finance Minister, they're very welcome, and they correspond to the objective of looking at faceless assessments, the faceless appeals of ensuring transparency and accountability. So I'm sure those are very well taken objectives. They can be taken forward in a more rational manner. I'm sure these are welcome measures for that matter. Thank you, everybody, for listening, and sorry for the delay in that internet connection. Thank you.
Thank you, sir. Thank you, sir. Thank you so much, sir. RS, just a second. So there is an order which has been passed, Gaurav and Taran, by Honorable President in his own style, that he expects a booklet after this meeting. and that order can be should be put on the website like he puts all his orders. We'll also put it on the website.
That is what used to happen 24 years also. You reminded me of that.
I used to do that. And used to vet it. I know that. I remember that. That's what I'm saying. So we will certainly do that, sir. And thank you so much. Over to you, Anas.
Thank you, Pannu Saab, for your words of wisdom. Very kind of you to find time for us. And we hope you are going to participate in this for whatever time that permits you. And we would look forward to your, suggestions as we go through this this meeting. And now I request Taran and Gaurav to take over and explain the provision and then involve the experts with you. Over to you.
Okay, thank you, Ahuja ji, for inviting us to this webinar. My warm regards to Honorable Shri Pannu ji, President ITAT, Shri Varshney ji, and all the other experts on the panel today. Friends, so first, what we have done is we have handpicked certain important provisions wherein amendments have been made. And so we are not discussing all the provisions, we are discussing only contentious issues. And to start with, we have picked up the most talked about provision, that is 139(8)(a), which have been discussed in the opening remarks by Mr. Wadhwa, also commented upon by Mr. Varshney and Mr. Pannuji. So friends, I'll first give a brief overview of what the amendment is, then my comments on the amendment, and then I'll rope in my experts to give their comments on the provision, and then we can invite comments or suggestions from Mr. Varshney. So friends, 139(8)(a), as we discussed, it's a provision relating to updation of return already filed or not filed by an assessee. In the last year's budget, we saw that time to file revised return or belated return under section 139(4) or 139(5) was partially reduced, that is 9 months from the end of the assessment year, and the time to complete the assessment or to issue the notice for assessment under section 143(3) was also reduced as 3 months from the end of the relevant assessment year. Now, with this reduced time, since the time left to file the updated return was reduced, it's a welcome move by the legislature to bring in this new section 139(8)(a), which provides an extended time to the assessees to update their return in case there has been any miss in filing the original return, revised return, or a return was not filed, and especially considering that a lot of data is populated through the information system mechanism on the ITBA portal. Now, the time given to file this updated return is 1 year from the end of the assessment year or 2 years from the end of the relevant assessment year. And why I'm saying 1 year or 2 years is that if the return is updated within a period of 1 year from the end of the relevant assessment year, then there is a payment of additional tax to the extent of 25% of the total tax liability along with interest, education cess surcharge. So additional tax is on the total tax along with interest or maybe any fee also. I think there's a confusion whether fee will be included or not, which Mr. Varshney can justify. But given the intent, it appears that whatever will be the total tax outflow when a revised return is to be filed, the additional tax is to be computed on that. So if it is filed within 1 year, then the additional tax is 25%. And if it is filed within 2 years from the end of the relevant assessment year, then the additional tax is 50%. And the interest under section 234(a), B, C will be computed up to the date of filing the updated returns. So while 234(a), B, C will be computed on the principal tax, there is no 234(a), B, C on the additional tax component. So the tax along with interest that will be computed at the time of filing the updated return, additional tax will be computed on that. And there will be no further interest under section 234(a) and 234(b) on the additional tax. And there has been a specific amendment in section 234(a) and 234(b) where it has been clarified that interest under those sections will not be levied on additional tax. And what are the cases wherein this updated return cannot be filed? There are a host of instances when this return cannot be filed. The first is that if the return is a loss return, or if the updated return results in reduction of income or increase of refund, then the updated return cannot be filed. The most contentious issue which we will discuss in our analysis is that the updated return cannot be filed when the assessment, reassessment, recomputation, revision is pending at the time of filing the return of income. Then when information has been communicated that an assessee's case is selected under PMLA, Black Money Act, Benami, etc., any prosecution proceedings have been initiated on the assessee, then he cannot file an updated return. Information has been received under agreement under section 1998, that is the foreign references that are given under FTTR division, through the FTTR division. Those cases cannot be taken up for updated return. Or search is initiated, survey is conducted, or requisition is made for that assessment year, the updated return cannot be filed. And in case of search, survey, requisition, then even updated return cannot be filed for preceding 2 assessment years. So these are the bar on filing the updated returns. Now, sir, I have few questions on this. Is that it has been provided that a return cannot be filed in case it is a loss return. So this point, maybe my experts can also supplement, but my point would be in case the assessee wishes to increase the loss, then why shouldn't he be allowed to update the return? That could be one point. And then, sir, this word pending, the word pending has always been very contentious. So the existing jurisprudence on the word pending is that when the return is processed under section 143(1), and when the time to issue notice under section 143(2) is lapsed, we have a lot of jurisprudence on this, then the return is not said to be pending. And considering that now the time limit to issue notice under section 143(2) has substantially been reduced, then in applying those cases, return would not be pending in most of the cases, even if there is no issue of 143(2) notice. Even if there is a time lapse in issuance of notice under 143(2), the return would not be considered as pending, and therefore it may come outside the purview of updation of return. So possibly this expression can be reviewed, and more time or this clause per se may be removed, so that more time is available for the assessees to file the updated return of income. Now, the other issue, friends, which I want to highlight is leaving aside the issue whether 143(2) is issued or not, whether in case of 148, now we have a new procedure of first issuance of notice of inquiry under 148A, and only once the assessee passes the muster of 148A that the notice is issued under section 148 of the Act. So whether when only I am at the stage of 148A, can it be said that the return is not pending, and therefore at the time of inquiries going on under section 148A, I'll be allowed to file the updated return in terms of new section 139(8)A of the Act. So these and then this amendment is with effect from 1/4/2022. So a clarification may be issued whether this return can be filed for assessment years 22-23 onwards, or any return which will be filed after 1/4/22 will be eligible for updation of return. So possibly this clarification can be issued. So these were few questions from my side, and then I'll invite my experts. I'll first rope in Mr. GC Srivastav to give his view on this issue of updated return, any observations he have, and then we can take the proceedings forward. I invite Mr. GC Srivastav, please.
Thank you, Gaurav. This is a very welcome move, and it has been, going on for some time. Thought was already there, but then this has been brought in at a very timely stage. And already the rationale has been explained by even Kamlesh ji in these proceedings before his initial address. So there is not much except to comment. I will not be repetitive. Only one, that this would be a non-starter unless that anomaly of the pendency of assessment, that is taken care of. Those expressions, because that is the whole idea, that if assessment is not made till that time, one has the liberty to file that return and update his position. And those information, etc., will keep on coming till that time, which will be taken note of by the AO at the time of final assessment. So that purpose would be served only if this is relaxed in whatever form. Yeah, I can appreciate the concern would be that it may not be put to some misuse, but then there are ways and means to do it. I think Mr. Kamlesh has already taken note of all those things. Will be taken care of, should be taken care of to make it workable. That's all. Otherwise, the rest of the things have already been pointed. About last return, this is something which I believe, this has been there in the institute for so long, that restrictions on the filing of the loss return, that has not been disturbed. So not to expect that even higher loss can be or revised or revisited. So let that be remain. This is serving a definite purpose, and that purpose should be seen when this provision is examined. Thank you.
Thank you, Mr. Srivastav. May I request Mr. Rakesh Gupta, please, to
Yes.
give his views on this?
But I have got several points to make, Gaurav. You'll have to give me time.
Yes,
First of
pleasure,
all,
sir.
certain observations and certain potential things, which can be taken note of. Now, you said about its applicability. Of course, on or after 1st April 2022, now, according to my humble understanding, the back returns, that is for assessment year 2021 and 21-22, whose time limit will expire 24 months from the assessment year on 31st March 2023 or 24, that can be filed updated return, number one. Number two, it would require some amendment in section 270 capital A, because there is nothing in section 270 capital A which takes care as to what would happen about the penalty, whether this excess amount, which is shown in the updated return, can be said to be underreported income. So section 270A subsection 2, which says that a person can be said to underreported income in which circumstances, that number two. Number three, in the first prohibitions, return of loss has the effect of decreasing the total tax liability, results in refund or increases refund. Now, one situation probably now is still uncovered, and whether it has been purposely left or now suppose there is a company which is paying tax under MAT, and under the normal income, suppose he wants to reduce that income, and thereby the tax credit under section 115 JAA that increases. Probably that situation is not covered under first three situations. So that is the point which I wanted to make. The fourth point is the second set of prohibitions, that notice has been issued to the effect that any money, bullion, etc., belonging to such person. Now, I want to ask a question to myself in the light of amendment which was made last year in 148, whereby this person is also issued notice under section 148 simpliciter. Now, what kind of a notice is being contemplated based upon which this person would know that his money, bullion, jewelry, valuable article or things, books of accounts, etc., belonging to him, pertaining to him, have been found at somebody's place? Had it been a case of section 153C, I could have understood that things belonging to him must have been recovered from somebody else's place. That is why this notice has been issued. Therefore, this has to be explained in the light of the amended law in section 147, 148, that notice has been issued. Notice under which section has been issued, and whether in 148 notice it would be indicated to him that his money, bullion, jewelry, valuable article or things have been found. Kindly be aware. Then, moving further, this person who has been searched, Gaurav, this person who has been searched or surveyed. Now, what is denied to him? He cannot update the return for the year of search or year of survey, and two preceding assessment years. Assessment years. Now, even a person who has been searched or surveyed now is still competent to file updated return for the third year, and that I will prove it. Suppose in April 2022, somebody is surveyed. So his assessment year will be assessment year 23-24, right? Now, he will be debarred from filing updated return for assessment year 23-24, 22-23 and 21-22. But for assessment year 2021, whose last date will be 31st March 2023, this person can file his updated return for assessment year 2021. Now, whether it has been purposely left or it is an accidental omission, And then I have not been able to understand as to, okay, the year of survey I can understand, but then why to deny a person from filing updated in the preceding 2 years? So this is that thing. Then next, of course, much has been said, and I have heard Kamlesh ji also in some other forum also. Now the next set of disabilities. Now it says any proceedings for assessment, reassessment, recomputation or revision. Now no section has been mentioned. It's very strange. No section has been mentioned. But this assessment word now probably is sought to be read by all of us dehorse the word reassessment or recomputation. If you see the scheme of section 147, everywhere these three words have come together: assessment or reassessment or recomputation. Therefore, this is my humble interpretation that this assessment should not be seen in isolation, more particularly when there is no section mentioned, and more so when the period of passing an assessment order under section 143 is only 9 months from the end of the assessment year. So with this contrived so with this restricted time for passing assessment order, then to deny a person that he cannot update his returns preceding 2 assessment years, now that it appears to me, though Varshney ji has been at the forefront in drafting this, therefore he can better tell, but then assessment or reassessment or recomputation, according to me, in the absence of any section, and since these three terminologies have been used in section 147 together, should be taken to mean that only. Then the assessing officer has information in respect of this Black Money Act. Now what is the information? Now information may be incriminating information, information may not be incriminating information. Like in section 1991 also, information. Now in exchange of information, it is not always necessary that the information which comes would always be incriminating. So whether any information, I mean, to be given in such a manner, such a omnivorous and all-embracing manner, now whether, I mean, can be said to be in consonance with the entire scheme. Then communication, as Ajay sir has also pointed out, Gaurav has, and communicated. I mean, what is the procedure of communication? Like in the black money cases, even prior to that notice under section 10(1) is issued. Now inquiry is made by the investigation wing of the tax department. Now whether you have got this account. Now, so communication, what does it mean? It will have to be spelled out. Otherwise it can, I mean, it can be very, I mean, chaotic. Then communication meaning for which assessment. Yes. Now kindly see next disability. Any prosecution proceeding, kindly see the way this clause has been worded. Any prosecution proceeding under the chapter 22 have been initiated for the relevant assessment year. Now, even that prosecution for that assessment year may not have any relation with the income. Suppose a person withheld the tax and then did not deposit for a particular assessment year and prosecution has been initiated against him. Now, do you want to deny the benefit of filing updated return even in the face of such kind of a prosecution which has got nothing to do? Then kindly see what credit should be given, what credit will be given while calculating. Ajay sir, kindly, you are with me now, sir.
Sir, I am noting every point. I am only wanting to retract the speech that I gave. That no counsel, I now say no counsel should be associated with the budget making exercise, because if a person like you goes there, there'll be no loophole left. That's all. I'm watching everything. So
now kindly see. Now,
no. I'll just say something more to what Ajay ji said. If such counsels are there, no law will be made.
Sir, because maybe after 5 or 10 years, then some amendments come that it was not in legislative intention. So it's better to take care of certain things at this stage. Now kindly see what kind of a credit can be given. Under section 140B subsection 1, it says the first is the amount of tax, if any, already paid as advance tax. Now advance tax has got a definite meaning under section 2 clause 1. That says the tax which has been paid during the financial year itself. Now if somebody has paid, say, not advance tax, but some tax in April, May, June, July, but then could not file the return. Now he wants to file his updated return. Now whether that tax which has been paid post 1st April Now, whether that can be allowed or not, because if you read section 2, clause 1, then advance tax has been given a meaning. Therefore, though equity says that if I have paid something, I should be given credit, but then I am trying to point out that where, I mean, what can be the contentious issues later on. And then next, now kindly see regarding that fee, Gaurav, that fee has been covered. So on that score there is nothing. But then kindly see subsection 2 of 140B. In section 140B2, if a person has already filed his return originally and he wants to file updated return, Ajay, kindly listen. Regarding subsection 1, since you have not filed your return originally, 234A is there, and that has specifically been that SSE shall be liable to pay such tax together with the interest and fee payable under any of the provisions of this act for any delay in furnishing the return. Now, kindly see corresponding clause in subsection 2. When I have filed my return originally, it says the SSE shall be liable to pay. Gaurav, are you there?
Yes, sir.
The SSE shall be liable to pay such tax together with interest payable under any provisions of this act for any default. Now, I have not been able to appreciate now what can be the interest under any because the interest can be under section 220 subsection 2 also. Interest can be under section 2011 capital A also. So whether along with this updated return, whatever interest is due, deholds this updated return, whether that is also sought to be covered. I mean, because when I can understand if the return has not been filed, okay, I mean, interest on delayed filing of return is all right. But when the return has been filed, even in normal assessment, we see when we have filed a return, maybe of the lesser amount, but then 234A is not levied. I mean, later on when the assessment is made. But then here shall be taxed together interest payable under any provisions of this act for any default. Now, in subsection 1, it was specifically pointed out that interest or on account of the delayed filing of return. Here, nothing has been mentioned, but it has been mentioned in a very, very comprehensive manner. Regarding advance tax, Gaurav, you raised, it is there that advance tax will have to be computed with reference to that updated, I mean, that tax is there on the updated amount. So that is there here. So I noted out these points, and one more thing. I think as of now, I mean,
नहीं अगर याद आ जाए तो कोई आप बिल्कुल कोई दिल की भड़ास छिड़िएगा मत भाई साहब. You have done a fantastic job. मेरे ख्याल से RS, let us keep this seminar only on updated returns today. मुझे लग रहा है क्योंकि हालात कम.
While you're saying this, even I was thinking कि जिस तरह से हम डिस्कस कर रहे हैं और वार्ष्णेय सर की अगर अवेलेबिलिटी हो तो जहां तक हम पहुंच जाएंगे इन डेप्थ के बाद एक बारी और एक सेशन कर लेंगे.
नहीं, वार्ष्णेय साहब को जाने नहीं देंगे. मैंने आदमी भेज दिए हैं इनके घर पे, तो अब पूरा ही करके छोड़ते हैं.
एक जमाना था जब हम लोग कुछ खिला देते थे हमारे मेंबर्स को भी, पर अभी रूखी सूखी पे कितना चलाएंगे. बट लेट्स सी, आई थिंक वार्ष्णेय सर शुड रिएक्ट टू दिस. सर, आप
we are all very eager to listen to you, sir.
Yes. So basically, let me respond to a lot of points which have been made. So first is loss return point, which was made by Gaurav. I think GC sir also, in a way replied to that there is a provision in the Income Tax Act which says that you will be entitled to carry forward your loss only when loss return is filed under 139(1). So that position has not been disturbed. So therefore, loss return provision is there that you cannot file your loss return. But I didn't understand what Gaurav said when he said that if my loss is increased, I mean, I'm assuming that it should be when my loss is decreased. Because if you want to file your updated return, your loss will decrease. Because if some income has been omitted by mistake and you want to include that income, your loss will decrease. But the other way is that if suppose I forgot to claim some TDS or some tax credit,
yes,
which I want to claim now, Now that is not anticipated under updated return, because for that you already have 1192B. So that is already there. You can file your claim for relief, refund of taxes which you did not claim earlier. For that there is already a provision. So that is not sought to be covered under this new provision. Then return pending. I mean, I don't think there is any provision that return is pending. So Gaurav was discussing that return is pending. That 143(2) time has gone, so return is pending. No,
assessment is pending, sir. Assessment is pending.
Yes. So return pending is not used anywhere in the section. Assessment pending. So let us come to that assessment part. Yes, assessment, reassessment, recomputation is used in 148, what Rakesh ji said, but assessment can also mean assessment under 143(3). You cannot exclude that because section is not mentioned there. So one cannot presume that when I'm using assessment, reassessment or recomputation, it means only 148. It could also be under 143. And let us try to understand that only 0.4% of cases are covered under assessment. So more than 90% cases are not selected for scrutiny under 143(3). So basically, if we say that this is going to non-starter because assessment is covered, I think that statement is not, in my humble view, is not correct. Though I mean, your point can be considered, can be discussed whether assessment can be excluded from this provision, that they may be given an opportunity to update return, because what is pending is basically, AA judgment is there, particularly in the context, because in AA cases also it was there that when assessment is pending, you cannot file AA application, and then it went up to the Supreme Court, and then it was decided that you are 143(2) notice. Along with that, you give 142(1) notice, and you write what information you want. What are the items on which a reply is solicited from the taxpayer. Then the court said that if the point on which you have gone to AA is not covered in that question, then that means you can go to AA. So that is a very relevant judgment, and I do understand that some clarity would be needed here, on that aspect, that what is pending when we say assessment is pending. But yes, if no notice has been issued, then absolutely there is no doubt that assessment is not pending. If your 143(2) notice or 147 notices have not been issued, then you can very well take recourse to this updated return. Then amendment in 270A was referred to by Rakesh ji. See, I tried to read 270A. It never says that underreporting of income is to be counted from your return file under 139(1) or 4 or 5. It doesn't say that. It just say it is to be counted as your return income, and we have said in 8A also that this is also taken as a return income. So so that doubt should not be there. If there is any doubt, let us say that we have taken power that removal of difficulty is there. So removal of difficulty provision have been inserted in the Income Tax Act for last 2-3 years. For example, you saw them under 194O, you saw them in 194Q and 206C, and we have issued circular for removal of difficulty under those sections. And we that power has also been taken for this section, and these kind of clarification can be given. Probably, one will have to examine, but because it is not possible to do legislative intervention, government amendment for small things. Something which is there in the act, because 270A does not say that you have to impose penalty on this, but if there is any doubt, that can be clarified through a circular. Then
I'm sorry sir, 270A subsection 2 में जो clause C है ना sir, that may create problem. Income reassessed is greater than the income assessed or reassessed immediately before such reassessment. So this can create a problem that assessment with reference to 139(8A) return as reduced by the income already assessed with reference to the original return. So that can create problems.
So Rakesh ji, when it say income assessed or reassessed is more than, so only if this updated return is taken for scrutiny again, because it can be That is why we have done amendment in 153, because it can be taken up for scrutiny again. Only when it is taken for scrutiny again, and then the assessed income is more than the return income, it refers to that position. So anyway,
सर इसको देख लीजिएगा, मैंने भी इसको देखा था सर. हाँ, please.
So company paying tax under MAT, that provision was there, that income increases. So if we read the section, it says that after the tax credit, under even MAT credit is written there. So after the MAT credit, there should be an additional liability. So that probably if we examine that point, so this could be more clear, but we can examine it again. Then it is a question, Rakeshji said that search has been conducted in somebody else's case and notice has been given to me, but it is not clear under which section. See, it is not notice. The word uses communication, not notice. So communication could be by investigation wing also, and that is how it happens. Suppose search is conducted in Mr. A case, and it is found that there is some document pertaining to Mr. B, or Mr. A says that this cash belongs to Mr. B. Then investigation wing communicate or issue summons to Mr. B. So that is the communication. It does not.
It is notice, sir. I'm sorry, sir. It is notice. Communication is for 90A and PMLA Benami. उसके लिए है सर. इसके लिए देखेंगे ना सर आप.
Okay.
Second proviso में clause C और D है, वहाँ notice है सर.
Okay, I will examine it.
Yes sir. Yes sir. Please.
ठीक है, तो उसको भी देख लेते हैं कि नोटिस का क्या प्रोविजन है.
Yes sir. Yes sir.
Then that example which was given of April 22 survey, that yes, that's a in my view that's a good point. So probably we need to examine that aspect, that survey is conducted in the month of April of 2022. Then immediately that person can go and update its return for assessment year 2021.
Yes sir. Yes.
Right. So that point we will examine. And I also agree with Rakeshji when he replied to Gaurav's question that this provision is applicable from 1st April 2022. So what does it mean? See, whenever we read the law, we also have to see notes on clauses or explanatory memorandum, that whether that 1st April 2022, which is written, is a procedural or it's substantive. That means whether it is from assessment year or whether it is from a date, 1st April 2022. So in this case, it is a date, 1st April 22. It does not say assessment year 22-23. If NOC or explanatory memorandum had said that this will apply from assessment year 22-23, then in that case, prior to assessment year 22-23, you were not eligible to update your return. But that is not written there. That means on 1st April 2022, you open the Income Tax Act and you see these provisions there, which allow you to update your return of 2 years before. You can update your return for 2 earlier years. So I don't think there is any doubt on that, and there is any need to issue any clarification for that purpose. Then information, whether it is incriminating or not, I think if we put that condition that it should be incriminating, then there will be dispute on what is incriminating. So, that probably will make it more complex, this particular provision. So idea is whatever information has been communicated, that should suffice. So I think that is why there is no intention to use any other word before information.
But sir, may I, I'm sorry. Sir, if suppose information comes, suppose किसी का बैंक अकाउंट है, वो जो उसने डिक्लेयर किया हुआ है, फिर भी इंफॉर्मेशन मांगी, वहां से आया, हाँ इनका ये बैंक अकाउंट है, तो then the assessing officer may say information has come under section 90, even if that information, is already there in the return or by some other means. Now, can that be the basis for denying me the benefit? That was the.
No, अगर information आपकी सब सही है, तो आप वैसे भी अपडेट नहीं करेंगे ना रिटर्न, आप समझिए. देखिए, अगर वो इंफॉर्मेशन ऐसी है कि जिसमें सब कुछ एक्सप्लेन ही है, तो आप क्यों अपडेट करेंगे रिटर्न?
बहुत सारी और भी चीजें हो सकती है.
नहीं साहब, अपडेशन नहीं, इनका पॉइंट ये है साहब कि अगर वो इंफॉर्मेशन आ गई which is already existing, then I can't update. I'm debarred from updating in toto.
Qua other there or other thing also, sir. That is what my purpose.
नहीं कर सकता. तो ये notice can be very dangerous, and also communication का भी बड़ा डेंजर. अगर आप जैसे कह रहे हैं इन्वेस्टिगेशन विंग जो है किसी फॉर्म में कम्युनिकेट कर देता है, तो वो कम्युनिकेशन है. इसको कुछ स्टैट्यूटरी बना दीजिए, because this will be subject to abuse.
You know how things are. One could get a phone call saying कि मैं ये देने वाला हूं आपको. नहीं तो मेरा ये कहने का मतलब है, of course I come to this, आप अभी आंसर कर रहे हैं कि ये एक तो ये इंफॉर्मेशन की जो बात है, इसमें क्लैरिफिकेशन बहुत जरूरी है. अगर इंफॉर्मेशन बेनाइन है, ऑलरेडी डिक्लेयर्ड है, that should not debar me from everything else. That's the point. That's the point. Is that correct?
See,
Yes.
let's try, Ajay, let's try to understand. Are we making it too complicated? See, we are starting something new which has never been experienced before.
Yeah.
You know, let's start this. If we put too many, conditions, कि अगर मैंने communicate कर दिया, अगर ऐसा communication है तो ठीक है, और ऐसा communication है तो नहीं है, और ये communication इसके लिए है तो इसके लिए नहीं जा सकते, दूसरे के लिए जा सकते हैं. You know, do we really want to make it complicated at the initial step where we want to make this scheme successful?
सर already 13 provisos हैं सर इसके ऊपर. तो
अरे तो आप 13 क्या आप 30 चाहते हैं क्या 13 की जगह?
30 नहीं सर, इसी existing में ही कर दीजिए सर.
राकेश अभी करते हैं, अभी साहब को और पॉइंट्स रह गए सर.
तो actually see, try to understand this. See, if this law is there and this law is for the benefit of the taxpayer, law is also for the benefit of the tax department. You know, it's not only taxpayer, because tax department also wants that their resources must be concentrated on tax evaders and not on regular taxpayers. So let's give a start to this scheme. You know, there are provisions that CBDT can always issue a circular. At any time, if CBDT feels that if this information is communicated, then, to that extent, you cannot go, otherwise you can go. Instead of putting in law, CBDT has power to issue this direction. That power has been taken under this section. So it is not necessary that everything has to be done through legislative intervention.
Right.
The moment you put in a law, it becomes complicated. And then it becomes prone to misuse. CBDT circular can always be revised and, can always be clarified. So it's important that something should be done through a circular and something should be clear in law. So that aspect is very... Yes, sir.
May I think, Mr. Varshney, you have done...
Please.
So, Varshney, I think the clarification that you have given on the concept of this measure is something that needs to be appreciated. And that is how it has to be taken. You see, the point is, even the department has costs to bear. Even it has resources which are limited to be diverted at places which will yield better results. Say they need to increase their tax base. So therefore, this measure should not be seen as something to be extracted from administrator of taxes, but something which is there to facilitate the task of making assessments of people seamless, both from the side of the officers also. See, those exceptions in 13 number are perhaps a bit too many, but you see, now the effort should be that those exceptions should go down as the officers gain more confidence in this, and the taxpayers also respond equally. See, they are getting a lot of data, and they're putting it in public domain, which is for the benefit of a taxpayer. They started the provision with something for which there is an omission. So yet, we have not reached a stage where you could also include the acts of commission also. So I think as you go by and implement these provisions, the omission will become very secondary. Cases of omission will become secondary. The next step would be for the department to ensure that even small acts of commission, what Mr. Rakesh Gupta has in mind of information and all. So even those acts of commissions can be brought in. And that will require for you to prune down these exceptions of 13 that you have. This probably is a beginning, but from the point of view of the department also, one has to see if the department continues to see to increase the tax burden by a tax base by only looking at tedious cases. I think those days are gone. You have to move forward. You have to look at such a big unorganized sector of the economy which is there. You tax them, you detect them only at the stage when that unorganized sector is in the verge of creating asset creation. You see, when the small unorganized businesses, they grow into creating assets, that's the time when you detect them. But your focus should be to see to it that those who are already potentially taxpayers there, they should be detected. And merely looking at tedious provisions to look at that, probably I think when you need to also look at other things also. But anyway, it's interesting to hear all this. It's more of a policy framework.
Sir, वाशने साहब, sir.
Thank you.
Sir, अभी और आपके पॉइंट है ना, एक दो रह गए.
हाँ, yes, few points are left.
जी सर.
एक prosecution को जो exclude किया है, and then example was given that prosecution may be launched for non-depositing TDS. I think from the department perspective, this is a very grave offense, because when you deduct TDS, it is in your fiduciary capacity. You know, when you do not deposit that TDS, then what is happening is you are depriving somebody else, whose TDS it was. He gets into problem because his tax has been deducted by you and you have not deposited to the government, and he struggles to get tax credit. So let us try to understand that it is not a very simple offense for which you say that, you should allow to update your return. It's your duty that once you deduct TDS, you should deposit within the time that is allowed under the Act. Then,
sir, sorry, I should not be doing this. Sir, TDS is one example, but there is prosecution even for non-appearance. Potentially, if I do not respond to one notice of the AO, it can lead to prosecution. So even for a very minuscule, a technical offense, I can be ousted. I'll come to. So TDS को अगर आप छोड़ दें तो और भी offenses हैं. हमारा ये कहना है साहब कि जैसे आपने बड़ी अच्छी तरीके से बताया that you cannot put everything in the law, but you can always come back through the CBDT this thing. We'll of course discuss this when we are towards closing.
अजय, IDS और VS के केस में भी ना इस तरह की डिसेबिलिटी थी. Somebody went to High Court और High Court ने कहा नहीं, ये वाली prosecution will not come in the way of filing with IDS. Yes.
Correct. तो मेरा ये कहना है साहब कि आज ये अभी हमने 17 issues रेज हुए हैं, doubts, and ये जो doubts हैं, ये जितने लोग देख रहे हैं सबके माइंड में doubts हैं, और आप भी जैसे clarify उनको कर रहे हैं, you are stressing to clarify. So point is, after this, suppose we send you all these questions and you get more when you are discussing. FAQ एक रेस कर दीजिएगा इन सब का, बात ही खत्म हो जाएगी. चाहे आपको लगता है कि वो बड़ा, it doesn't even requires an answer, still say so, reiterate that. मेरा ये कहना है कि साहब देखिए, this is a step which is a brilliant step, और उसमें डिपार्टमेंट का बहुत बड़ा ऑब्जेक्टिव है अपने लिए. हमारे लिए तो है ही, आपका अपने लिए बहुत बड़ा है. एक, आप लिटिगेशन खत्म करना चाहते हैं. दूसरा, आप असेसमेंट की जो खर्चा है उससे बचना चाहते हैं. आप पहले धमका देना चाहते हैं आदमी को, ये देख बड़ी इंफॉर्मेशन है भैया आ जाओ. सो ये आपके लिए बड़ा भारी बेनिफिशियल स्टेप है, एंड यू शुड इंश्योर दैट यू सक्सीड, and you will only succeed if you put all the information that you have in respect of an assessee before issuing a formal notice to him. इसे भी देख ले, ये है, नहीं तो otherwise this is going to happen to you. So therefore my respectful submission is that whatever doubts that we have raised, even if they are innocuous, they're not very credible, you answer them by way of an FAQ if you want this to succeed. I'm telling you, sir, and it is a great step not only for us but a great step for you too. That's all I wanted to say. And that's why I said कि डॉक्टर राकेश गुप्ता या जिन्होंने ये जो हेयर स्प्लिटिंग है, तो बड़ी इंपॉर्टेंट है, ये आएगी आगे तक, क्योंकि ये लोग डॉक्टर राकेश गुप्ता तो खाली बैठे हैं, इनके साथ बीवी है नहीं, इन्होंने तो केस करने ही करने, 17 केस करेंगे ही करेंगे, हम देख लेना. इनके पास 500 क्लाइंट से आना है और ये केस, ये जजमेंट है, ये गई हाई कोर्ट, आप देख लीजिए. इससे पहले FAQ कर दीजिए साहब. मेरा
नहीं, देखिए वो तो मैंने आपको पहले कह दिया ना कि the removal of difficulty power is there, so those will be taken care of whenever this issue arises, and that is why see, law cannot be drafted which will cover all situations. Correct. So you got to have that power which is already there.
FAQ.
So another point was 140B 1 subsection 1, which deals with where no return has been filed earlier, and it talks about self-assessment tax. So yes, we will check that. We will definitely examine that, and probably I don't know why a particular person will pay self-assessment tax and will not file return. That's something very but yes, this will be examined. And about that 234A interest for late return filing, if you see section amendment in section 234A, it says that when second return is filed, then we will not revise 234A interest. It says clearly. So, but if it is a first time return, that means you had not filed the return earlier, then 234A interest will be counted.
Yes.
Till the date of filing. But it has been filed earlier, then we will not revise 234 interest.
But
It is
my point was that which kind of interest to this subsection 2 is talking about?
No, 234B, 234C.
No, that is separately given, sir. Kindly see that the assessee shall be liable to pay such tax together with interest payable under any provision of this act for any default or delay in payment of advance tax along with the payment of additional income. So delay in payment of advance tax, that is being taken care of by the subsequent portion. But then this first portion is talking of which interest, at least I have not been able to further appreciate, Your Honor.
No, so see, whatever, I mean, basically, what I'm saying is if there is no other interest, there is no other interest. You understand? But 234A has been clearly mentioned that it will not be revised.
Parliament is known for not using, the useless words. That is also one principle.
No,
anyway, I wanted to bring it to your kind notice. Kindly see.
Okay. So these are the points which I think I have, responded to all the points which have been raised.
Sir, one more point, small point. As I pointed out, no interest under 234A, B is payable under on additional tax because there is a specific amendment under section 234A and B. It will be payable only on the principal tax, but there is no similar amendment in 234C. So since it is an additional tax, if updated return is to be filed as per the current provisions of 234C, I will be paying 234C on this additional tax also.
No, Gaurav, you won't be paying because 234C is counted on the return income.
So, sir, this is updated
on
return.
Assessed income.
This is an updated return.
No, but additional, that I have said, 234C will be counted on the income that you are returning. It is not counted on additional tax even otherwise. Otherwise, then Dr. Rakesh Gupta will say, why have you made this amendment? It was not required.
Sir,
thank you for your clarification.
Sir, एक चीज और गौरव ने उठाई थी कि reassessment can be said to be pending even when 148A notice inquiry is being made or not. Because earlier we used to understand that reassessment cannot be said to be pending unless 148 notice is served. So, or issued for that matter. Now, after 148A, when inquiry is made and then that inquiry's result would accompany with 148 notice, now at which point of time can it be said that the reassessment is pending? So that is one point.
Yeah, sure. So this would also we will look at.
Ajay, sir,
VP साहब आपका
very short.
बस एक
very short. Hey, sir, 2 points just which have already been raised, and in fact we are grateful to Mr. Varshney who has replied each of the points. Sir, regarding just 2 points. One is the loss return, because the present provision says that in case of a loss you cannot file the loss return. But as you rightly said that if the income is being added, then there will be a decrease in the loss. So what the word should be that in case of increased loss, one cannot file the return. So the word at present word is that one section will not apply when it is a loss return. So if your intention is that if I am adding some income and loss is being decreased, then restriction should be only in that case where there is an increase in the loss or the same loss. But when there is a decrease in the loss, then I am just disclosing my income. So that probably needs clarification.
Gupta ji, I replied to that. So I replied to that also that when you include your income and reduce your loss, that also not allowed for the reason that loss return must be filed within time.
Sir, loss return was already filed. For example,
so even so this you know
I am reducing the loss in fact by declaring the income. So that you may consider that in that situation, it is in the interest of the department.
Sir, tax भी ले लो ना आप. Loss को reduce करके tax भी 25% ले लो. क्या दिक्कत?
वो ले लो. That is possible.
सर ना मत करना.
सर दूसरा point जो है आपने कहा assessment आपने you rightly said in these words the restriction जब any proceeding or assessment is pending, you said the assessment can be 143(1) assessment also. Very right, sir. But now since as Rakesh has already mentioned, that period is only 9 months for completing the assessment. So once the assessment is completed, those words should be excluded from here in relation to 143(3), sir. So that is what I just wanted to reiterate. Thank you very much.
अच्छा, अब I think इस पे we've had sufficient discussion, sir. Do we move on to the next?
Yeah.
Gaurav, yeah, Taran. who is taking up
Taran,
what?
please come in.
So next is mine, sir.
Yeah.
This is regarding the litigation management with the new section 158 AA, which is in proposal. Now, earlier 158 AA, sorry, 158 AB is now coming in, and earlier it was 158 AA. The department, there was the department was not filing an appeal when for that very SSC the question of law was pending before High Court or Supreme Court. Now the proposed new section says that even if that question of law is pending before High Court or Supreme Court in any other case, and the collegium feels like that the question, this question of law is there in other matters also, then the revenue is not going to file an appeal against the CIT appeal order or against the ITT order to the next higher appellate forum, since that question of law is pending in some other SSC's case. Now, sir, few issues are arising on this. As we all are aware that when the question of law is pending in some other case, inevitably the assessing officer in the assessment order says that in one line he says that the facts of the case are different from that case. Then how is the collegium going to take care of those cases? Second, what happens in a case where the CIT appeal order or the ITT order has that question of law plus some other issues also? How do we take care of such? Because the intention is to avoid unnecessary litigation. Third, sir, in 158 AA, as you are aware, that the question of law was pending in the case of that very SSC. So he had a right to argue the matter for the higher court where the question of law was pending. But in this case, is it the intention that once the no objection is given by the SSC, even for some other case, question of law is pending, he forecloses his right to argue that question of law before any appellate authority, and he only has to wait for the final outcome of the matter before that higher appellate authority? These were the few issues which I wanted to highlight. And I'll just like to request GC sir and Rakesh Gupta sir. Rakesh Gupta sir, if you want to highlight some other issues on this.
सर मेरे पास एक दो चीजें हैं कि इसमें सर सबसेक्शन 4 देखें सर 158 AB का, इसमें लिखा है where the order of commissioner appeal or the order of the tribunal is not in conformity with the final decision of the question of law in the other case, as and when such order is received, the principal commissioner may direct assessing officer to appeal to the appellate tribunal or the jurisdictional high court, as the case may be, against such order, and save as otherwise provided in this section, and all other provisions. Rajiv bhai, इसे बंद कर लें जरा please. Then all other provisions of part B of chapter 20 shall apply accordingly. सर मैंने देखा ये part B of chapter 20 ये ट्राइब्यूनल अपील से रिलेटेड है सर केवल. तो क्या जहां ट्राइब्यूनल का ऑर्डर ट्राइब्यूनल के ऑर्डर के अगेंस्ट में अपील थी और इस तरह से हमने उसको पेंडिंग रखा, तो क्या हम 254(2) में जाने का सोच रहे हैं सर हाई कोर्ट का ऑर्डर आने के बाद, या हाई कोर्ट में अपील कर? बिकॉज इसको मेंशन करने का क्या मतलब था कि ऑल अदर प्रोविजंस ऑफ पार्ट बी ऑफ चैप्टर 20 शैल अप्लाई अकॉर्डिंगली. सेक्शन 260 नहीं आता सर उसमें जो हाई कोर्ट को अपील करने की पावर देता है. तो इसको क्या मतलब वी आर थिंकिंग कि वंस हाई कोर्ट ऑर्डर एंड क्वेश्चन ऑफ लॉ कम्स, then instead of filing appeal to the high court, let there be application under section 254 to the appellate tribunal to rectify?
No.
सर पॉइंट्स अभी नोट करते जाते हैं. राकेश और बता दो फिर साहब एक ही बारी.
नहीं बस एक दूसरा तो ये है कि इसमें चूंकि एसएससी की कंसेंट लेनी पड़ेगी और एसएससी कंसेंट अजय वाधवा काउंसिल से लेगा, तो अजय तो नहीं कहेगा कि नो ऑब्जेक्शन दे दो, तो ये एक प्रैक्टिकल प्रॉब्लम आएगी. क्यों अजय?
हाँ नहीं ठीक है. अब तुम
बाकी तरन ने जो मेरे मन में पॉइंट थे तरन ने ले लिए हैं.
हाँ ठीक है. अब जीसी श्रीवास्तव साहब.
Yes. So first thing that this is a step to manage litigation only in cases where taxpayers have succeeded and revenue is to file an appeal. So some of the issues Mr. raised, I think that is taken care of. The other point important is that Honorable President referred to collegium. Yes, that's true. I mean, AOs can always take the decision. But from practical point of view, I think the collegium concept is there only to give that courage, I would say, or the ability to take the decision of not filing appeal. probably because sometimes the tax effect is so huge that they would not take the risk of not filing the appeal. So if a collegium takes a decision, I think it's a better perspective. And then second advantage would be that would be taking an all India perspective of managing such questions and not confined to what the question which is there before. So a larger perspective would be there. So that's all a very welcome move in the management of, but it should not happen that, yes, the consent of the taxpayer. That is also important because otherwise it would be difficult at a later stage to really filing the appeal. Lots of other questions will arise. So I think this is a very welcome move. And Rakesh ji has pointed out a couple of things which
sir, maybe I also have one or two issues. Sir, isme essentially the collegium is going to step in after the CIT bill passes an order. Is that right, sir? Now you have only 60 days for that. तो पहले तो collegium trigger होगा, बैठेगा, उनके पास information जाएगी, और फिर वो decide करेंगे, फिर वो approval लेंगे, फिर PCIT communicate करेगा. ये जो speed है, ये जो time period है, 60 days वाला, ये कहीं इस पूरे procedure को meaningless ना render कर दे. Number two, nobody stops the AO from filing the appeal against the order of the CIT bill within 5 days of the receipt of the CIT bill order. Then the whole thing becomes meaningless. So the point is, achha, why after CIT appeal? Let us say if I raise the issue before the AO, ye point covered hai, and let us say he doesn't agree. I go to the collegium then only, and let the issue remain there. उसको अपील का प्रोसेस आप चालू ही ना करो, वहीं से चालू कर दो, ताकि why should I go before the CIT appeal, wait for him to say that this issue is covered. Suppose the CIT appeal doesn't say it is covered, although it is covered, मैं फिर litigation में चला गया. Tendency CIT appeals की काफी रहती है साहब, because उनके पास power, their coterminous with that of the assessing officer. उनका ये रहता है कि कहीं नहीं है covered. And it is covered actually. So once they say so, and I feel it is covered, I again go into that litigation trap. So my suggestion is hai, bring it soon after assessment and let the information flow as to whether it is covered or not from the assessee. क्योंकि यहाँ पर collegium को कौन बताएगा कि ये covered है कि नहीं covered है?
Ajay, that would be an appeal by the assessee.
Exactly. तो मैं ये कह रहा हूं ना कि फिर कैसे पता चलेगा कोलिजियम को 60 डेज के अंदर ये सब चीजें कैसे हो जाएंगी? That's the point. फिर एक और मेरा पॉइंट है that let us say ये सारा कंसेंट दे दिया and the matter travels to the Supreme Court. Now Supreme Court ने SLP dismiss कर दी at the threshold against the order of the High Court. अब उसका क्या है? Now does it become law for all? Is the withdrawal of appeals for all? क्योंकि दो इंटरवेंशन हो सकती है, एसएलपी डिसमिसल हो सकता है यार, और सुप्रीम कोर्ट की जजमेंट तभी अप्लाई करती है जब अपील अलाउ हो या डिसमिस. दैट एंगल आल्सो नीड्स टू बी सीन. दीस आर द पॉइंट्स सर. और बाकी पन्नू साहब का बड़ा इंपॉर्टेंट मुझे पॉइंट लगा कि ये जो कॉलेज पीसीआईटी का डिसीजन सर, इट इज अ वेरी सिंपल इशू. अगर आपने स्पीड करनी है तो उसको कोशिश करना है कि 60 डेज में मीनिंगफुल हो, कॉलेजियम बैठे ना बैठे, सीसी आपने अपॉइंट किए, यू नो हाउ मच टाइम इट टेक्स, गिव इट टू द पीसीआईटी टू डिसाइड. दीस आर द पॉइंट्स सर. वीपी
सर अनम्यूट करें सर, वीपी गुप्ता साहब अनम्यूट करें.
Sir, if we see the background of the section 158A was inserted in the Act on 1st October 1984, and then provision of section 115AA were added from 1st June 2015. But in how many cases these provisions are being resorted to either by the SSC or by the department, that is very important to see. In my personal view, these provisions are rarely being resorted, otherwise they are not being resorted. So even if we make the provision now, by 115 AB, probably the status is going to be the same. Therefore, as our Honorable President also mentioned, and Ajay Vadva has also just said, that we have to simplify the scheme to make the things effective and reduce the litigation. And in my humble opinion, for kind consideration of the board, if we can just provide the rectification process in 154, say in 1 year, my matter is going before the Commissioner, Tribunal, and High Court and Supreme Court. Commissioner has decided in my favor. Then in the next assessment year, let the assessing officer allow me the claim, and subject to 154 can be amended in that way. So whenever the order of the earlier year is changed by the Commissioner or ITAT or High Court or by the Supreme Court, then subsequent years can also be, because now earlier the difficulty has been to keep the track of the things. Now, when we have the all computerized system, digital business, so this should not be a difficult thing. So instead of repeatedly giving consent or following the process that I will file the appeal later on and all that sort of things, if 154 are just amended to say that earlier year's decision will apply to the future year, and there can be time limit for the giving effect to that order, so that can serve the purpose if for kind consideration. That is what my point.
Tavandeep, I just forgot to write your first 2 points. Sorry. Can you just come up again? Your first 2 points. Third point, I have written that SSC Forgo is right. So he doesn't get chance to represent. What were your first 2 points?
Sir, first point was that when we are talking about that question of law is pending in some other case, in what happens in every matter is just like Vadva sir pointed out, that assessing officer and the CIT appeal in writes a line that facts of this case is different from that case. So what will the collegium do in such cases? Second is that, for example, take a matter that CIT appeal or ITT order has some that question of law plus some other issues also. So is it like विवाद से विश्वास कि आप सारी अपील के लिए जाओगे या एक particular question वेट नहीं करेगा?
ठीक है. I think okay. See, first point which Tavandeep said that officer can say or collegium can say that these facts are different. I think that is something for CBDT to administer, because this scheme has been brought in to reduce litigation, and we are fully aware that the earlier schemes were not successful. What Gupta ji also referred to it. He asked the question, how many cases? But one reason could be that the scope was limited, so that scope has been widened now. So that point has been addressed. Another issue could be that we did not have technology at that point of time that we can keep track of the cases where we are foregoing our right, and our computer system should automatically flash to us that now the decision has come in your favor, so you exercise your right to go to the appeal. So that technology was not there earlier, which is available now. So those we expect that with these two developments, this new scheme with much better provisions would be successful. Now, if even then it is not successful, for the reason what Tavandeep has said as his first point, then it is for CBDT to see that such things should not happen. Because, if a substantial question of law is similar, then this provision should be exercised. One should not just say that it is not similar. So that has to be ensured by CBDT. But of course, CBDT cannot ensure that some other point which Gupta ji has said, that, we will go to SSC and SSC council will say, no, it is not similar. That we cannot control. So that we will
happen.
To,
for example, in software royalty cases, matter Supreme Court pending tha, but still the lower assessing officer and the DRPs and the CAT bill used to write it is no, the facts are different from, let's say, Nokia or Infrared, which were pending in Supreme Court. But so unnecessary litigation was taking place.
Yeah, so that's why I'm saying that, this has to be administered very well by CBDT. So CBDT can always control his officers, and if facts are same, if substantial question of law is same, then CBDT has to implement it, and then only it will be successful. So that point is very well made. But the second point, I think, see, you try to understand the concept that we want to reduce the number of litigation. Now, if in an appeal there are 4 points and 2 points are substantial question of law which are similar, and other 2 points are different, then probably there is no point not going in for appeal for the 2 points, because appeal will still be made for the remaining 2 points. So it is when you have to file an appeal, and then in the appeal that you are going to file, whatever points are there, whether 1, 2, 3, 4, they all are, identical question of law with some other case. So that has to be there. I think, so to that extent, no purpose will be served if you just don't go for 2 questions and you go for 3 other questions. So I think that is what the position is. Then the third point was that assessee forego his right, but he does not get an opportunity to, represent himself. Currently, the question of law must be identical in the case of assessee himself. So assessee knows that when it is going to come up in the Supreme Court, I'm going to get a chance to argue this case. But in some other case, if it is identical, and then when some other case comes up in High Court or Supreme Court, then assessee doesn't get a chance to argue. I mean, that is something which will remain. This is, an outcome of the step that we have taken, because when the earlier provision was there, when we used to, consult taxpayers that why this is not successful, they always used to say because it is too restrictive. You are only saying that identical question of law must be pending in my case. Why don't you allow any other case? So this is what has been allowed. But yes, so once we allow, so that, constraint would be there for that assessee when he exercises his option. So let us see, how many assessees give consent or whether they don't give consent because of this reason. So we will need to analyze that particular aspect and, take it when we actually experience such situation. But yes, the possibility is there. Then Dr. Gupta had made point. Dr. Gupta had made point about 158 AB4, that part B of chapter 22. I agree, probably part CC should also be mentioned. We will examine that. And collegium was mentioned by Pannu sir, so probably GC Srivastava to some extent have answered this question. The idea is that, let there be body to decide rather than the jurisdictional PCIT. So that was the idea, but the point which Ajay made is quite valid that, probably we need to see that time limit should not be too short. So that may have to be examined. And then there was this issue, that Ajay made, that bring it after assessment. But as GC sir also said that after assessment, it would become assessee appeal. And that Gupta ji also, was dwelling upon that point as well, that can we make it in assessment, that in assessment, assessing officer himself allows it and then rectifies it later on. These are definitely, all these are ideas. This scheme is there. So let us see how successful is this scheme. Then, these are alternative ideas, because we have not yet gone to that level where at assessing officer level, we are going to, defer addition or, something like that. But ultimately, yes, these are proposals which are to be considered for future. But let us see how successful is this scheme. Then Ajay also mentioned about Supreme Court can decide the matter in 2 ways. One is that SLP is dismissed and one is on merit. So see what we are saying is that SLP, which is pending in Supreme Court, is currently the High Court decision is in favor of the assessee. So now if SLP is dismissed, not admitted, so there is no occasion for me to go and file the appeal. It is only when in some other case that substantial question of law again is taken up by the Supreme Court and decision is given on merit, and on that merit the decision is in favor of the tax department, then only there is an occasion for me to go and file the appeal. So that part is clear, but yes, we do appreciate from the discussion, and even otherwise we know that this is something which probably we will have to see that what steps we have to take to make this particular provision successful, because we know that earlier provision was not successful.
Brilliant. That is why, Varshney Saab, we respect you and we value your advice. You are so open to ideas and so receptive, and you understand the issue so quickly. Thank you very much.
Gaurav, the next issue is yours.
Gaurav and Taran, I hope you're noting all these points and all the issues being raised by each one, right? Because we need to also make a representation, formal representation, after this is over, so that for the benefit of Shri Varshney and for everybody else. Okay? Now let's go on to the next point, please.
Sure.
So next, friends, we will move to amendments in section 148 and 148A of the Act. With the permission of chair, can I do a display? Since there are many amendments in this section, what I've done a comparative analysis of the earlier provision and the new provision to point out what is the difference between old and new. So possibly my idea was I'll deal with most of the amendments through the comparative analysis, and with each provision, my experts can come in and give their comments or explain the provision. So with the permission of the chair, can I display
the
the
chair
comparative
is
chart?
Honorable Shri Pannu, if he permits.
Pannu sir, please. Thank you, sir. Host will need to enable the screen sharing, please.
Screen sharing on कर दो, विनोद. ये गौरव तुमने बहुत बड़ी गुगली मारी है.
नहीं, उसके बिना सर ये प्रोविजन समझ नहीं आएगा.
मैं समझता हूँ, लेकिन जो होस्ट जिसको तुम कह रहे हो विनोद को, वो ये स्क्रीन शेयरिंग का जो है,
चलो क्रिप्टो की बात कर रहे हो तो बाद में कर लेना.
ठीक है, ठीक है सर, ठीक है.
देखो भाई, RS call up.
Is SB there? SB can help in doing it.
Call up immediately. This should not be very difficult.
जब तक next ले लो.
इसे next ले ले पहले अभी.
तो next ले लेते हैं. Next is deduction under section 43B. Am I right, Taran?
Yes, Gaurav. Yes.
So friends, next amendment is in section 43B.
Screen sharing has been allowed.
Has been allowed. चलिए, हो गया साहब.
Okay, all right. So the left side is the old provision, earlier provision, and right side is the proposed amendment. So the first amendment is in proviso to section 148. Now, as we saw last year that in each step, when the notice under section 148 was issued or 148A was issued, there were multiple approvals required from the specified authorities. So now one such approval has been removed. The first was that notice under section, even after 148A approval was given to pass the order, even at the time of issuance of notice, the approval of the specified authority was required. So now the amendment has been made that if at the time of passing the order under section 148A to issue notice, there is an approval by the specified authority, then the second approval at the time of issuance of notice under section 148 will not be required. So the new proviso reads, provided further that no such approval shall be required where the assessing officer with the prior approval of the specified authority has passed an order under 148A(d) of the Act. So this is the first amendment in proviso to section 148. May I invite Mr. Salil Kapoor also, who is the expert for this particular topic, and my experts can interject at any point of time if they want to raise any point with respect to the amendment. Now the second amendment is, friends, we now know that now under the new provision of 148, the notice can be issued on the basis of information. So earlier there was the basis for information was information flagged in the case of assessee on the basis of risk management strategy, or there was a final objection raised by the Comptroller and Auditor General of India to the effect that the assessment in the case of the assessee for the relevant assessment year had not been made in accordance with the provisions of this Act. So these were the only two bases of information on which notice under section 148 could have been issued as per the existing provision. Now the scope has sought to be expanded by making some amendment in this provision relating to information. First is a cosmetic change, that is the word flagged has been removed. Maybe Mr. Varshney can explain any specific reason for removing this word. Now the second amendment is the word
flagged word is superfluous. I mean, it's for just that what is flagged. Unnecessary, it could have given rise to dispute.
So it is more of a clarificatory kind of an amendment. Now the second is the word Comptroller and Auditor General of India word has been removed. So it is any audit objection to the effect in the case of assessee, the information, the notice under section 148 can be issued. The third amendment now is the inclusion of
Gaurav, I mean, though my question may not strictly be relating to this amendment, but this I mean, does it not widen the scope in the sense when it says that assessment has not been made in accordance with the provisions of this act? So there may be situations where an assessment cannot be said to be made in accordance with the provisions of the act, even if it may not be leading to the escapement of income. So can such audit objection also be the basis for reopening the assessment of, suppose audit objection is this, that this income does not belong to this person, this income belongs to somebody else. So whether even such kind of audit objections are intended to be covered under this, though it has got nothing to do with, because it was already there under the final objection of CAG, also the same expression was there. So I thought that.
But sir, this is part of the explanation. I think the main provision of section 148 still remains, which requires that income should escape assessment in the case of assessee. So unless that condition is satisfied, possibly because in case of any other assessee there is information, this section cannot be roped in. That's my view on this.
Second example, let me give you. Suppose if there was a short-term capital asset on which the tax rate was 30%. Okay. Now, whereas somehow the tax rate which was applied as if it was a long-term capital asset, income in both the situations remains the same. Now, it will not be covered under the main provision, but it can be covered under this provision on this premise that the assessment has not been made in accordance with the provisions of this act. So whether, I mean, because in the example of this which I have given, it may not be covered in the main provision, then do you want to say it will not be covered? So explanation may be intended to explain the meaning of, I mean, even the main provision.
Point taken. Rakesh, point taken. I think, I'm sure Varshney sir would have taken note of it. Let's go on. Gaurav, complete. Okay. Point taken.
Now certain more insertions with respect to information is the other point which we even discussed in the earlier discussion. Any information received under an agreement referred to in section 90 or section 90A of the Act. So possibly again, it's a blanket provision of information, but if we read it with the main provision, possibly if the information leads to income escaping assessment, then that information could be used for issuing notice under section 148 of the Act. Now, the fourth is any information made available to the assessing officer under the scheme notified under section 135A of the Act. Now, to this, I think I'll request Mr. Varshney to clarify, because what would be the import of section 135A? This is not very clear because this is yet to come. This is what we understand, that this is a faceless mechanism of collecting information. So and information could be under section 133, 133(6), and there are more other provisions. So what is the intent of giving importance to this provision, which is found in subsequent sections also, 149, etc. And last is any information which requires action in consequence of the order of a tribunal or a court. Now, friend, this is something similar to section 150, which was there in the erstwhile scheme of section 148 and 147 of the Act, which required that when there is any order of a tribunal or a court, and on the basis of that order, if a reassessment could be initiated, that provision has sought to be brought in the new provision of 148. But the change is that in the earlier part, section 152 specifically provided that if at the time when the order which was subject matter of appeal before tribunal or high court, if at that time the proceedings to be initiated under section 148 were time barred, the notice under section 148 could not have been issued, even if there is a finding in the order of tribunal or high court. So that subsection 2 is not there in the new provision, and it's a blanket provision. So therefore now under the new provision, if as a result or as a consequence of the order of a tribunal or a court, there is any issue which requires to be taken up in the case of assessee, then notice under section 148 can be issued. So these are 3 new insertions and partial modifications with respect to issue of information. And now I may request my experts to elaborate or raise their points on this, if any. Dr. Rakesh Gupta and Mr. Salil Kapoor, please.
Salil, sir.
Yes, sir. Thank you, Gaurav. And,
yes, sir, please.
The first insertion, which is already mentioned by Mr. Varshney, that word flag was superfluous, so it has been removed. So that's a good sign, because it could lead to litigation. What is flag? What do you mean by flag? But the other 3 points which have been added, like information under section 90 and 90A of the Act. Again, we had discussed this earlier also, that the information needs to be qualified. Any information can lead to 148 is, I think it needs clarification by the board, as Mr. Kamlesh Varshney said, that these are the things which can be sorted out by the circular of CBDT, what kind of information is needed to inject this section. And also 135A, in respect of any information made available to the assessing officer under the scheme notified under 135A. As rightly said by Gaurav, 135A is again a faceless way of collecting the information. But the scheme of collecting the information 135A is yet to be notified, and this needs clarification that to what extent this can be used. Any information coming under 135A will bring into 148. This will again increase the scope, which is not required under explanation 1. And that's exactly my friend Mr. Gupta was also saying, Dr. Gupta, about this. And also in the next clause, it is any information which requires action in consonance of the order of a tribunal or a court. So it is not mentioned as the ITAT, it's mentioned tribunal or a court. This also needs little clarification. What do you mean by the directions or the consequence of any tribunal or court? I would request Dr. Gupta to further clarify on this.
Please. First of all, Gaurav, you referred about section 150 subsection 2 to say since there is no reference and therefore notice under section 148 can be issued merely on the basis of any order of a tribunal. It's not like this. If you read section 150, subsection 1 says notwithstanding anything contained in section 149. And if you read section 149, it says no notice under section 148 shall be issued. Okay. So 140 subsection 2 now overrides even the issuance of notice under section 148, number 1. Number 2, here the tribunal or a court probably may not mean income tax appellate tribunal alone. So it may cover any tribunal if there is some action which is to be taken pursuant to the direction or something which is contained in NCLT's order. So probably, I mean, they have referred. And if it means income tax appellate tribunal or court means high court in tax matter, then I would say why CIT appeal is also not there. So these are my takes, sir.
That's exactly what I was saying, asking Mr. Varshney to clarify. What do you mean by the tribunal and court? Whether it is limited to the ITAT and High Court or any other tribunal or any court can also be included in this.
So over to Mr. Varshney, please.
See, first of all, let us try to understand that this particular provision is not doing something new, because it was already there. That risk management strategy of the board. If board wanted these all 3I, 4I, 5I, all these could have been under risk management study. So what we have done is what executive could have been done. Now it is done through legislature. So which is a better step, you know. So it's nothing that scope has been widened. These things could have been done by CBDT by itself, because that power was already there. So that is first point we should appreciate. The second thing is, it doesn't mean that information has come from a treaty country under exchange of information. It will always lead to a notice. It only says that this is an information. Then of course, see, we need to understand, and this also takes me to 135A. That scheme has already been notified. So if you see that scheme of e-verification scheme has already been notified. And as I have said, in the context of updated return, I'm repeating it again, that 148 will not follow automatically. Whenever there is an information could be audit information could be 90, treaty information, it could be any other information. And when we say tribunal or court, it could be also any court. Dr. Rakesh correctly mentioned that it could be even NCLT court, it could be any other tribunal, motor accident claim tribunal, so that all that information will go through e-verification scheme. And through that e-verification scheme, assessee will get an opportunity to reply to that information, that whether his return correctly reflect that information, and he will have a chance to update his tax return. If not, then this information get passed on to the assessing officer, which is this 4I, any information made available to the assessing officer under the scheme notified under section 135A. This is I think I was muted in between. So basically this information comes in, and then after e-verification scheme, if it is noticed that the taxpayer has still neither explained this information nor has updated his tax return, then this information gets passed on to the assessing officer, and then it is deemed that this information suggests that income has escaped assessment because of this explanation, and then assessing officer can go and issue the notice. So this is how everything has been planned.
So possibly section 135A, how it reads, it did not lead to any incline of e-verification scheme. That was a more of a provision of collecting information in a faceless manner. Now, how it will be thrown, that was not clear from the reading of this section, and that's why this confusion has remained in the mind of taxpayers.
Okay.
When we see section 135A, it says the central government may make a scheme by notification in the official gazette for the purpose of calling for information under section 133, collecting certain information under section 133B, or calling for information by prescribed income tax authorities under section 133C, or exercise of power of inspect register of companies under section 134. So this is not as per the section. There is nothing relating to e-verification of returns.
If you see the scheme which has been notified under this section, then probably things will become clear.
Sure, sir.
I think Gaurav, और तो नहीं इसमें कुछ point?
Nothing.
So एक काम करते हैं. You see, we have already gone 2 hours 10 minutes after the session. Up you have, I can see that you have 18 points in total, जिसमें से भी 4 points हुए हैं. If we can quickly run through the points with Dr. Rakesh Gupta and the other experts, अगर उनमें लगता है कि हाँ, you can tell us कि हाँ ये important है, इसमें ज़्यादा point है, then we'll start to do that.
So I'll focus only on important points in this 148 and quickly move to next.
148 में भी और है points.
बहुत है, अभी बहुत है सर.
बहुत है सर इसमें
तो फिर 148 का ही करते हैं, फिर और तो point नहीं आने वाले मेरे ख्याल.
So next amendment is in explanation 2. Now explanation 2 to section 148 provided that what will be the cases where information will not be the basis for issuing notice under section 148, that is the search cases, survey cases, search and survey cases, that is wherever there is a search or survey happened, then automatically notice can be issued. Now the amendment in the aforesaid provision is that earlier it provided that when the search undertakes under section 132 or 132A, then notice will be issued automatically for 3 assessment years immediately preceding the assessment year relevant to the previous year in which search is initiated, etc. Now this word of 3 assessment years has been removed in the new provision. So what is the consequence of this removal? How I understood it was that earlier it was like a block of 3 years, that as and when search took place, the block of 3 years will automatically be opened. So by removal of this, the implication is that possibly now it will not be a block of 3 years. It will be only the year. The AO can issue notice only for the particular year for which there is an income escaping assessment. 1, that could be the implication of this amendment. 2, possibly this provision was restricting the reopening of assessment in case of such cases to 3 years, whereas we now have a criteria to reopen the assessments for 10 years. So possibly to take the power to issue notice for years beyond 3 years, this amendment has been made. So that was my view, that possibly the block of 3 years will not be required. Notice can be issued for any year where the income has escaped assessment, and it could go beyond 3 to 10 years. This amendment has been made. And I'll request Mr. Kapoor also to give his view on this amendment.
इसमें मैं एक इंटरजेक्ट कर रहा हूँ कि साहब पिछली बार वार्षिक साहब जब ये सारी FM ने कहा था कि अब देखिए 6 साल भी हमने कम कर दिए, हमने तो 3 साल की असेसमेंट खोलेंगे बस. And she got a lot of credit for it. The income tax department got a lot of credit for it. Now in one stroke, आपने सारी powers assume कर ली to reopen as many years and how in whatever manner पिछले 10 साल once the search take place. ये देख लीजिए साहब कि ये I hope it's not a retrograde step and going against the assurance given by the finance minister in the last step. Move on next.
Mr. Kapoor,
इसमें कुछ ऐड तुम्हारा पॉइंट ठीक है.
नहीं सर, मैं ऐड करूंगा सर.
हाँ राकेश जी बताइए इस पॉइंट के ऊपर.
सर इसमें ये जो 3 साल हटा के जो ब्लॉक वाली बात जो गौरव ने की, रादर अब ऐसा नहीं है. अब तो ये हो गया कि इन 3 सालों के खुलेंगे ही खुलेंगे. पहले भी यही निकल रहा था, क्योंकि आप ये देखा रीजन टू बिलीव को इन्होंने रिप्लेस किया एक्सप्लेनेशन 1 से. इंफॉर्मेशन सजेस्टिंग एस्केपमेंट ऑफ इनकम कहां होंगी उसको कोडिफाई कर दिया 4-5 चीजों में. और यहां पर लिखा है असेसिंग ऑफिसर शैल बी डीम्ड टू हैव इंफॉर्मेशन व्हिच सजेस्ट दैट इनकम चार्जेबल टू टैक्स हैज एस्केप्ड असेसमेंट. तो अब तो सारे सालों में सर्वे और सर्च के केस में ये माना जाएगा कि इनकम चार्जेबल टू टैक्स हैज एस्केप्ड असेसमेंट एंड असेसिंग ऑफिसर इज हैविंग इंफॉर्मेशन.
10 साल
3 साल नहीं 3 साल के ऊपर वाले केसेस के लिए जो 149(1)(b) की जो लिमिटेशंस है वो आएंगी बस. तो 3 साल एक तरह से वो पहले भी रिडंडेंट थे, अब उन्होंने उसको हटा के अब मतलब अब ये हो गया, कोई 3 साल की कोई रेलिवेंस थी नहीं, उसको हटा दिया उसे. ये मतलब है मेरे हिसाब से.
So it will be a block of 3
ब्लॉक
years.
क्यों कहते हो, मतलब सारे साल खुलेंगे, 3 साल के खुलेंगे.
अब नाउ
चाहिए उसे
3 साल तो होंगे, 3 साल तो होंगे
3 साल के होंगे और बाकी 3 से 10 के बीच में 149(1) भी होगा तो होंगे. ये है मेरे हिसाब से. तो
वार्ष्णेय साहब आप क्या कह रहे हैं?
सर आप म्यूट हो गए सर.
म्यूट पे है सर आप.
मैं भी ये कह रहा था कि जो डॉक्टर राकेश कह रहे हैं सही कह रहे हैं. ब्लॉक का कोई कॉन्सेप्ट नहीं है. 3 साल का रेफरेंस गलत था तो उसको हटा दिया गया है. Unnecessary it was there. That was a mistake from last year that has been corrected. So what Ajay is saying is basically amendment in 149 where the time limit has been increased. So that is but this is something different.
सर केवल टाइम लिमिट ही नहीं है सर, मैं उस पे आऊंगा 149 जब आएगा सर, उसमें बहुत सारी चीजें हैं. सर इनफैक्ट हमने अपनी किताब लिखी उसमें इसको करने के लिए थोड़ा दिमाग लगाना पड़ा.
I'll straight away move to 149 only.
नहीं 148B
which is important.
148B
Approval
so
है,
इस
वो
पे
तो-
इशू नहीं है मेरे ख्याल से.
Approval है.
नहीं एक इशू हो जाएगा सर.
हाँ बताइए
सर.
नहीं सर वो इशू हो सकता है इस अमेंडमेंट से नहीं संबंध रखता हो, लेकिन एक मैं एडमिनिस्ट्रेटिव पॉइंट से मैं सर जानना चाहता हूं कि किसी के यहाँ सर्वे हुआ सर, सर्वे में 148A की इंक्वायरी होगी क्योंकि वो डिबार नहीं है. वो इंक्वायरी करने से पहले चीफ कमिश्नर के पास जाएगा, उसके बाद 148D का ऑर्डर पास कर देगा चीफ कमिश्नर के पास, प्रिंसिपल चीफ कमिश्नर के पास जाएगा. ठीक है ना सर. अब प्रिंसिपल यानी स्पेसिफाइड अथॉरिटी इतनी सीनियर है, उन्होंने 2 बार माइंड लगाने के बाद कहा हाँ भाई हाँ 148 करो. तो अप्रूवल देते वक्त ऐसे, हालांकि आई एम कॉन्शियस कि अप्रूवल और उस वक्त की अप्रूवल में अंतर है, लेकिन किस जॉइंट कमिश्नर और एडिशनल कमिश्नर्स की सर एडमिनिस्ट्रेटिवली ये अथॉरिटी होगी कि एक जिसको एस्केपमेंट ऑफ इनकम के बेसिस पर चीफ कमिश्नर या प्रिंसिपल चीफ कमिश्नर ने अप्रूवल दी हुई हो और असेसमेंट करते वक्त वो कहे नहीं इसमें तो एडिशन नहीं बनती. तो ये एक में मतलब दिस इज डिहोर्स द अमेंडमेंट बिकॉज दिस वाज देयर इन 153D आल्सो, लेकिन एट दैट टाइम जो अप्रूवल थी वो नॉट फ्रॉम द स्पेसिफाइड अथॉरिटी थी. तो ये मेरा एक इसमें वो है सर.
ठीक.
This is
Now we move
Dr.
to
Gupta,
149.
this is more of a check and balance because when he is making the assessment, for that the approval is required under 148.
सर मैं शायद अपने को कन्वे नहीं कर पाया. चेक एंड बैलेंस तो है, लेकिन क्या वो चेक इफेक्टिव होगा, ये मेरा मतलब है सर.
क्योंकि और अदर प्रोविजन also 153D में भी सेम प्रोविजन थी, when 153A की और 153C की
चीफ कमिश्नर की अप्रूवल एस्केपमेंट ऑफ इनकम के बारे में नहीं होती थी सर. ये मेरा मैं प्रोबेबली आई कैन नॉट कन्वे माय सेल्फ.
वो फाइनल फाइंडिंग नहीं है.
That is there. That is why I said I am conscious.
Yes.
Now 149, now the time limit to issue notice was expanded from 3 years to 10 years in only specific cases where the income escaping assessment revealed that it was represented in the form of an asset. Now this expression invites a lot of debate and was also restrictive in some manner, and that is vindicated by the fact that the scope of this expression has now been amended under the new provision. The new provision expands the condition that the income which has escaped assessment should be represented in the form of an asset or expenditure in respect of a transaction or in relation to an event or occasion, or an entry or entries in the books of account which has escaped assessment amounts to or is likely to amount to 50 lakhs rupees or more. So meaning thereby, if an income has been found to have escaped assessment, that is not by itself sufficient to reopen assessment proceedings under section 148. The cumulative condition is that income must, on the other hand, be represented in the form of an asset. That was the old condition. Now it has been expanded that if there is no asset, if that income has been expended, then also this 10 years time limit can come in, or if that income is represented by an entry. So for instance, if there is an income in the form of a loan, which is sought to be added under section 68. Now there is no corresponding asset against that income. That income has also not been expended, but it is in the form of an entry, which is in the nature of a loan payable to the other party. Now that would get roped in under the new provision. So this scope has been expanded with the new provision.
Gaurav,
yes,
a small thing here. What you have said here is the clause 1, 2, 3. The language you have put in shows that the 50 lakh condition is only with 3. But it is not so.
It is with all 3.
It is with all 3.
Yes.
Because if you see the finance bill, this part is separately mentioned. It is not part of 3.
It is not part of 3, sir. It's a matter of how I have typed it, but it is for all 3.
Yeah. So there's a small clarification here that this 50 lakh limit will apply to 1, 2, 3, all 3.
All 3.
Not
it
only
will apply
with 3.
To all 3.
Not only with 3. Yes.
So
continue, Mr. Gaurav.
One finding that I would like to take from this is that this condition was even in the erstwhile provisions of section 153A and 153C of the Act. Now that was a subject matter of debate. Now possibly this amendment will give an argument that where it is the income escaped assessment is not represented by an asset, but is represented by way of an expenditure. Possibly that this amendment can come as a defense in those cases, in 153 and 153C old cases, that expanded time limit of 10 years will not apply in those cases. So this was my observation and explanation with respect to this amendment. Any comments from Mr. Gupta and Mr. Varshney,
please. Sir, first of all, it was not clear. It is not clear that it should be represented by an asset at which point of time, because any undisclosed income of these 3 natures would in any case be represented by any asset, even for a minuscule second at any point of time, because that income would come into existence in the form of some form of asset, maybe for a cash, maybe for the 10 seconds, then it may be converted into some other asset. So when it said that income chargeable to tax represented in the form of an asset, so according to me, that was covering all the 3 situations in any case earlier also, because as Gaurav has pointed out, the 4th proviso to section 153A used the expressions only represented by asset, and that may be for this purpose. Here it appears that the legislature, as a matter of abundant caution, has sought to use expenditure also and entry also. But one more thing, sir, Kamlesh sir, I always have raised this issue. Now those income escaping assessment as a result of some other provision of law like section 50C. Now why should that income, or for that matter 222E, or for that matter 43C, or for that matter 40A3, for that matter 40AIA, even all these sections also may indicate some disalliance that may be in the nature of income escaping, ultimately income escaping assessment which has to suffer tax. But then these things which I have just mentioned, they do not fall either under an asset, nor under expenditure, nor an entry or entries in books of account. So can there be, or was there any conscious decision, or it is just like that it has happened, that these kind of situations, if 3 years have passed, cannot be roped in for the purpose of reassessment, even if they are leading to the escapement of income to the magnitude of 50 lakhs or more. So that was one point.
क्यों नुकसान कराते हो यार?
अरे sir, I mean we are here.
ये मत बताओ यार. नहीं यार, एकेडमिक्स की बात छोड़ना है यार. हर चीज थोड़ी बतानी होती है.
Here we are discussing.
हर चीज खोल के नहीं बतानी होती यार. ये तो रहने देते बात. चलो इन्हें बता दी तो बता दी.
अच्छा. Then sir, next thing. ये आप सब अच्छा still technical dissonance escape represented which point of time? Yes, इसमें तो इतना ही है. फिर बाद में जो है 1A सर, जो 1A अभी हालांकि गौरव would speak but then since it has
ले आता हूं सर, 1A पे आ जाते हैं.
उसमें दो चीज क्यों ली है सर? उसमें एंट्री और एंट्रीज क्यों नहीं ली है? क्या वो कोई एक्सीडेंटल ओमिशन है या कोई कॉन्शियस है सर? वो जब ऊपर तीन चीज थी, एसेट, एक्सपेंडिचर एंड एंट्री और एंट्रीज इन द बुक्स ऑफ अकाउंट. बिकॉज इसको हमने ऐसे डेसाइफर किया. एसेट मींस 69, 69 है, 69 भी. एक्सपेंडिचर 69C, एंट्री और एंट्रीज इन द बुक्स ऑफ अकाउंट 68. सो ये सारा अनडिस्क्लोज उसका कवर कर लिया. लेकिन जब 1A का मौका आया तो उसमें इन द फॉर्म ऑफ एन एसेट और एक्सपेंडिचर इन रिलेशन टू एन इवेंट और ओकेजन को ही क्यों कवर किया, तीसरी को क्यों नहीं कवर किया? और फिर जो 50 लाख रुपए की लिमिट जो पर ईयर की थी पिछले साल तक, क्या हम 50 साल जैसे 153 में तो सर 50 लाख पिछले 3 या 4 साल के लिए एग्रीगेट थी, लेकिन यहाँ पर 149 में 50 लाख एक साल के लिए आ रहा था. तो क्या आप जो अमेंडमेंट जो किया है अब उसमें, क्योंकि इसमें लिखा हुआ है कि सारे सालों के केस खोले जा सकते हैं, तो 50 लाख क्या वो सबके लिए कंबाइंड हो गया है? ईयर वाइज नहीं रहा ये
नहीं, ये तो आप मुझे बताइए ना. देखिए मैं आपको अपना इंटेंशन बता देता हूँ.
इंटेंशन
हमारा इंटेंशन तो ये है, आप बिल्कुल सही कह रहे हैं कि पहले भी एसेट के अंदर ये सब कवर होते थे, और 140 जब वो 153 वाला असेसमेंट होता था तब ये होता था, और उसमें खाली एसेट लिखा था, रिप्रेजेंटेटिव इन द फॉर्म ऑफ एसेट. लेकिन तब भी नोटिस दिए जाते थे 6 साल के बियॉन्ड में. और उसमें 50 लाख की जो लिमिट थी वो 6 साल के बियॉन्ड एग्रीगेट थी, राइट? तो उसमें नोटिस दिए जाते थे एक्सपेंडिचर के लिए भी, और वही व्यू जो आपने कहा है वही व्यू लिया जाता था
जी.
ठीक है. तो अभी हमने इसको ठीक करना था इन द सेंस कि जो 50 लाख की लिमिट शुड अप्लाई टुगेदर, नॉट इन 1 ईयर. तो उसके लिए वो फॉर दैट ईयर वर्ड वाज रिमूव, और इसको इस तरह से किया. और ये 1A वाला एक्सीडेंटल नहीं है. 1A में क्योंकि ट्रांजैक्शन, आप देखो एक्सपेंडिचर के अंदर भी हमने ट्रांजैक्शन वर्ड रिमूव किया है 1A में. ऊपर एक्सपेंडिचर के साथ ट्रांजैक्शन भी लिखा है,
ठीक है.
और इवेंट और ओकेजन भी लिखा है.
जी हाँ, ठीक है.
तो एक्सपेंडिचर में ट्रांजैक्शन भी हटाया है और एसेट भी हटाया, ये एंट्री भी हटाई है, सॉरी नॉट एसेट, एंट्री भी हटाई है. क्योंकि रीजन ये है कि जो 50 लाख स्प्रेड होगा वो इवेंट और ओकेजन में होगा या एसेट में स्प्रेड होगा 50 लाख. एंट्री में तो 1 साल का ही देखना पड़ेगा. आप समझ रहे हो कि दैट इज आइडिया बिहाइंड. और ट्रांजैक्शन में भी अगर ट्रांजैक्शन है एक्सपेंडिचर इन द फॉर्म ऑफ ट्रांजैक्शन, तो उसमें भी 1 साल में ही देखना पड़ेगा 50 लाख.
हाँ, ठीक है, ठीक.
सो दैट इज आइडिया. अब वो गलती कितनी है वो आप बताइए, बट मैंने आपको अपना आइडिया बता दिया.
अब सर मैं इसको देख के पढ़ के आई विल गेट बैक टू यू सर.
हाँ, ठीक. और आप अजय जी को मत बताइए, सीधा मुझे फोन करके बताइए.
नहीं सर, ये तो
I think amendments तो बहुत हैं अजय जी, but these were the contentious issues which warranted some clarification. So we can stop 148 here and move to the next provision.
Can we? Are you?
Maybe my experts can say in case there are any questions.
Experts को अगर कोई something very tangible, something very important you think needs to be raised, flagged here. Otherwise, we can move on to the next. But Gaurav, let's be mindful of one fact. It's been 2.5 hours that we are into it already.
Yes.
If you think कि हम लोग इसको pause लेके वार्षिक साहब की assurance ले लें in a very short while, let us say in the next 5, 6, 7 days, we can even
ऐसा ही करना चाहिए सर, वरना फिर जल्दी करने से कोई फायदा नहीं होगा सर.
वार्षिक साहब सब आपके ऊपर है सर.
हाँ, ठीक
अगर आप चाहते हैं आज हमने करना है तो we have no issues. The whole day is available to us.
नहीं, अभी मेरी पत्नी मुझे परेशान कर रही है. वो सब कोई तो गुप्ता जी की तरह नहीं है ना कि पत्नी साथ में नहीं है.
वो भी आ गई है सर, वो भी आ गई सैटरडे.
अच्छा. सब किस्मत वाले नहीं है सर. लेकिन ठीक है, कोई बात नहीं सर. ऐसा मेरा तो फिर ऐसा करते हैं, साथ पॉज लेते हैं. लेकिन आप समय बताइए अब नेक्स्ट हम कब आ सकते हैं?
नेक्स्ट सैटरडे कर लीजिएगा.
नेक्स्ट सैटरडे जाना है. So जितने लोग अभी यहाँ पर हैं, let them be informed that next Saturday, same time 11 o'clock, we are meeting for the rest of the clauses. Is that correct?
Yes. It will be in continuation of today's meeting.
It will be in continuation of this proceeding. As it is. अब एक वोट ऑफ थैंक्स के लिए बीपी गुप्ता साहब।
सर
अरे अब लेकिन आपने लंच तो करवाया नहीं, बाद में करवा देना जब
पहुंच गया आपकी वाइफ
सर लंच का ठेका मेरा
पहुंच गया सर।
अजय सर अब रिस्ट्रिक्शंस कम हो गए।
यू आर वेलकम फॉर लंच एनी डे सर, आप अपनी कन्वीनियंस बताइए।
हमने अब ये सैटरडे के बाद restrictions अब खत्म हो गई हैं and we are going to celebrate this and thank you formally for this and we'll have a big lunch and invite all the important dignitaries along with you sir. You've been so kind to us. तो lunch की तो बहुत ही छोटी चीज है। We'll celebrate with booze जो डॉक्टर राकेश गुप्ता नहीं लेते। हाँ बीपी साहब बताइए।
हाँ, I'm thankful to Ajay for giving me this opportunity of thanking everybody. Actually, this has been a very lively discussion, as always we had in ITAT meetings. So this was an excellent day, and in fact, each of the provisions which we have discussed threadbare, and I am really grateful to Varshney sir, who has explained each of the issues which have been raised, and we are sure that he has taken note of everything, and some fruits will come out of all these discussions. And we are really grateful to the Honorable President of ITAT who has been present and who has blessed us with these things. And obviously, the Ajay Vadva, as always, has made so many very important issues and all that, and kept the discussion lively. And in fact, we are grateful to each of the participants and experts who have joined and made the discussion livelihood. And thanks a lot to everybody. And we'll continue with this discussion on the next.
And sir, he makes it lively at my cost. That also, sir, you must mention.
Whatsoever may be the causes, he always make it lively.
I have to admit that Dr. Rakesh Gupta gave maximum food for thought for us to discuss for government amendment. So thank you so much.
Sir, we are all of us are open for that, and we don't want one-sided. Everything this way or that way, provision should be properly understood, so the litigation is good, and everybody's works is easier. Right? Grateful to you.
Thank you so much, VP. So two announcements. One. This, whatever we have discussed today will be uploaded in the YouTube. Number two, if Karan and Gaurav, there are 29, I think, issues raised on chat. So if you could take a note of that, so that whatever has been left unaddressed by way of request from our members.
अजय अभी कॉपी कर लेना, बाद में नहीं वो अवेलेबल होंगे, समझ लेना।
अभी कॉपी कर ले,
अभी कॉपी कर लेना, हाँ, वरना बाद में नहीं होते वो।
बिल्कुल ठीक है। तो अभी इसको
वो रिकॉर्डिंग तो आएगी ना, रिकॉर्डिंग में हो जाएगा। नहीं होते सर, नहीं होते
चैट के नहीं। तो चैट का तो अभी आप इमीडिएटली तरन ले लो, उनकी एक स्नैपशॉट ले लो, so that you are able to answer those. And YouTube का भी हो जाएगा, सिनॉप्सिस भी हमारे हो जाएंगे। एंड साहब 11 बजे सैटरडे का आपके साथ फिक्स रहा। Thank you so much. Thank you so much, everybody. Really grateful.
Thank you. Thanks, everybody. Thanks.
Sir, thank you.
Thank you.
विनोद अभी बंद मत करना, जब तक चैट कॉपी ना हो जाए तब तक पूरा क्लोज मत करना।
सर चैट में नीचे ना, चैट बॉक्स में राइट पे 3 बिंदियां होती हैं, उस पे क्लिक करेंगे, सेव चैट दबाएंगे तो पूरी चैट सेव हो जाएगी।
अरे वाह, थैंक यू सो मच, थैंक यू। कर लो भाई, 3 बिंदियां देखो,
बॉटम पे है बिल्कुल।
यार आप भी सेव कर लो।
मैंने कर ली सर।
ठीक है, फिर तो भेज दो मुझे यार।
मैं डाल देता हूँ।
Grateful to you. Thank you so much. Okay, bye everybody. Have a nice weekend.
Bye.
Bye.